Yes, you can't hear me? Are we on? Thank you. This is the February 26, 2020 formal hearing of the Utah Board of Oil, Gas, and Mining. We're meeting in Salt Lake City, Utah. Our first agenda item is docket number 2019-026, cause number 007-15, in the matter of Spencer K. Barton. This matter was continued in January, and we're now going to hear it today. So with that, we'll take appearances of counsel.
Gordon Rowe from the Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
Thomas Kessinger, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Proceed. Anyone else? Seeing none, proceed.
Chairman Gill, members of the board, this matter is an enforcement matter brought by the division requesting that the board authorize the forfeiture of Mr. Barton's bond to reclaim a well site and requesting authorization from the division to seek civil penalties against Mr. Barton in district court. Before reaching the merits of this case, there are some procedural matters we need to address. First, it appears that neither Mr. Barton nor his legal representative are here at this time, so we'll need to address the issue of default. Under Rule R641-104-150 and R641-108-400, the board can choose to continue this matter, dismiss this matter, or issue an order of default. In this matter, the division will be making an oral motion for default. However, before making that motion, I think it would be helpful for the division to outline a proposed set of procedures. So first, the division would make its motion for default judgment. Next, we would propose for the board to rule on this motion before reaching the merits of this case under Rule 641-104-154. The board would then have the option to grant this motion, continue the matter, or dismiss the matter. If the board grants this motion, the rules require the board to conduct any proceeding necessary to complete the hearing without the defaulted party and determine all issues of the party. In this case, the division is prepared to present its case in chief and has staff to testify to the issues in this case. So are there any objections to this procedure from the board?
Just to be doubly clear, so as you see this hearing playing out, you're making a motion of default.
Correct.
And that has the result of what?
It would issue a default order from the board, but the rules then require the merits of the case to still be reached. It's kind of a funky procedural rule.
So that's just a preliminary step in getting to the final decision?
Correct.
Okay. Will part of your presentation discuss service of process?
Yes, I'm prepared for that.
Okay. And is that of record?
Yes, it is in our supplemental exhibits.
Mr. Chairman, I would move that we accept the division's
Motion of default?
motion of default.
Is there a second to that?
Second.
The motion before you is to grant the division's motion and in effect order that this is now a default proceeding. Is that the proper way to say this?
Yes, that's correct.
Any discussion of that motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Let the record show that was unanimous. Okay, back to you, Mr. Rowe.
Great. We're having a little technical difficulty here. Are we able to get the presentation up on this input?
Steve can see it on his laptop.
Okay, here we go. So here's going back to the matter of default. Sorry, it wasn't showing up on our screen. Here, Exhibit Z shows the personal service was made on Mr. Spencer Barton in Farron, Utah by the Emery County Sheriff's Office on October 31st, and Mr. Barton was notified of the continuance of this hearing to today here in Salt Lake City.
Thank you very much. So we have given him, we did continue the hearing as the rules allow. We have given that opportunity to Mr. Barton, and we've also given him personal service.
Correct. Yeah, we had a little bit of trouble tracking down Mr. Barton, but we were able to personally serve him.
I think that's more than adequate then. Okay, proceed.
So the Division of Oil, Gas, and Mining is asking the board for an order to forfeit Mr. Spencer K. Barton's interest in the $15,000 cash bond held by the Utah State Treasurer and to release the funds to the division to plug and reclaim the Academy No. 1 well in Emery County, Utah, as required by Rule R649 3-1.16. Additionally, the division is seeking an order to authorize the division to seek civil penalties against Mr. Barton in district court under Utah Code Section 4611. Finally, the division seeks an order to authorize the division to take court action as necessary to enforce the terms of the order and any further relief the board deems proper. The division is requesting this relief because, as this presentation will show, Mr. Barton has continually disregarded and violated the oil and gas rules, statutes, and division orders. Mr. Barton's actions have created a potentially dangerous and damaging situation at a gas well just outside the town limits of Farron by failing to act as a prudent operator. The division's request to plug and reclaim the subject well is required under the rules and will allow the division to prevent damage to the reservoir and protect public health, safety, and the environment in a timely manner. Additionally, the division's request to collect penalties from Mr. Barton will allow the division to plug and reclaim the subject well without financial assistance from the taxpayer. Mr. Spencer K. Barton is the operator of record for the Academy No. 1 well, located on an agricultural operation less than 1/2 mile from the town limits of Farron, Utah. Mr. Barton received approval and drilled the Academy No. 1 well in May of 2017. Since the first day of drilling the Academy No. 1 well, Mr. Barton has been in violation of oil and gas rules, and the well has never produced oil or gas in its over 2.5 years of operation. The well has remained shut in without division approval since June of 2017, and no evidence of downhole integrity has been submitted to the division. Rule 649-336 prohibits an operator from shutting in a well for more than 12 months without division approval, a plan for bringing the well into production, and evidence of its downhole integrity. Mr. Barton and his agents have not maintained a field presence at the wells, and after an order from the division, Mr. Barton has indicated he is unwilling and unable to plug and reclaim the subject well and has failed to provide information on downhole integrity. Therefore, Rule 649-3-1.16 requires the division to take this action in front of the board. I think it's important to explain why this action is brought against Mr. Barton personally and not against his entity known as Empire Energy. According to the Division of Corporations, Empire Energy is a DBA of Mr. Spencer K. Barton, making his oil and gas operation a sole proprietorship. Under Utah law, a proprietorship has no formal existence, and the proper defendant in such a circumstance is the individual owner of the business. Therefore, the division was required to bring this action against Mr. Barton rather than Empire Energy. As is typical practice before the board, I'll move to admit the division's exhibits at the conclusion of my presentation. And with that, I would like to begin my examination of Mr.
We'd like to swear the witnesses.
Yes, we'll be having Mr. Dustin Doucette and Joshua Payne testify on behalf of the division.
And will you have anyone be giving expert opinion?
I'll be qualifying Dustin Doucette as an expert in petroleum engineering.
Okay. Let's swear the witnesses at this time.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Okay, with that, I'll call Mr. Doucette, who will, I would like to qualify as an expert in petroleum engineering. So, Mr. Doucette, would you please state your name and position for the record?
Yeah, Dustin Doucette, petroleum engineer for the division.
And have you been recognized as an expert in petroleum engineering by this board in the past?
Yes.
What specialized degrees or training do you have related to petroleum engineering?
So I have a bachelor's of science in petroleum engineering, and graduated in 1991, and have been working in the industry since that time, and getting training and et cetera since that time in the field.
So what relevant work experience specifically have you had in petroleum engineering?
So during school, I worked pumping wells and doing special engineering projects in the panhandle of Texas. Moved on working as at core laboratories, doing reservoir analysis, gathering and evaluating reservoir data, and coordinating overseas projects for companies like BP and ARCO. And also at TerraTech, I did similar reservoir analysis, and then coming to the division, I've overseen the engineering aspects of regulation here in Utah, overseeing operators, approving engineering designs and approvals, working with those companies to overcome problems and remedy issues according to what our rules and regulations and good engineering practices allow. And part of that is also overseeing the orphan well plugging program, where I put out to bid and oversee those projects to get wells plugged.
And as part of your duties with the division, have you helped issue permits and regulate the Academy No. 1 well?
Yes, I have.
With that, I would like to move to have Mr. Doucette recognized as an expert witness in the field of petroleum engineering for the purposes of this hearing.
Board members, any objection? We're very familiar with Dustin Doucette's high level of expertise, and he is so admitted.
Thank you. I'd like to move to Exhibit A, which is a two-slide exhibit in this presentation. So, Mr. Doucette, would you please describe the location of the Academy No. 1 well in relation to the town of Farron?
Yeah, so here on Exhibit A, this is a map representing the area where the well is located. The red outline is the city limits of Farron, and there's a little pink or magenta dot there.
Hard to see. I think we'll move to the next slide, which is a zoomed-in version to show this pink dot, I think is what you're describing.
Yeah, that represents the location of the Academy No. 1 well.
Approximately how far is the Academy No. 1 well in relation to the town limits of Farron?
It is less than 1,000 feet, as indicated. That red outline is the city limits, and so just outside the limits of the town of Farron.
Okay, we'll move to Exhibit C. Would you please describe this exhibit?
Yeah, this is the bond document for the Academy No. 1 well. It represents that it's. We originally had a bond in the amount of $1,500, which was our normal depth bonding amount for a well under 1,000 feet. They had deepened the well during drilling to over 1,000 feet. Hence, we ended up getting the required $15,000 bond. It is a cash bond that we hold for this well.
And which wells or well does this bond cover?
This only covers the Academy No. 1 well, the subject well that we're discussing today.
Next, we'll move to Exhibit L, which is this plugging and reclamation plan. Would you please describe this exhibit and whether you produce this exhibit under your supervision or control?
Yeah, Mark Jones had developed this under my supervision and oversight, and this is a P&A diagram representing the required plugs to properly plug and abandon this well in accordance with our rules and regulations to protect and isolate the producing formation and any other water-bearing or mineral-bearing formations.
And would you please describe how the plugging and abandonment process works on the division side of things once they're authorized to plug a well?
Yeah, so typically the operator will develop their plugging plans and submit to us, and then we'll review, similar to what we've done here with this diagram, their plugging plan, make sure it's in accordance with our rules and regulations. And then they'll get the approval, and then we'll have oversight on and ensure that the plugging goes according to what's been approved. In the cases where they end up becoming orphan, we kind of do that process. We'll write the plugging and abandonment plans, go through assessing what our cost estimates are for those wells, go out to the Division of Purchasing and get the approval to go out to bid, and then evaluate the bids that come in from contractors or potential contractors, and award the bid to the lowest, most responsible bidder that is available.
Great. We'll move to Exhibit M. Would you please describe this exhibit and how it was produced?
So this kind of is as an extension of that plugging plan. This is more on our orphan well estimate side of things. After we've developed what the plugging plan was, we went through the time and man hours that would be required to plug this well and put it on this kind of unit cost or well cost estimate sheet. And the total we see there is, the estimate for this well is approximately $69,000.
And is this a typical procedure you use for estimating a plug and abandonment cost for a well?
Yes, this is what we use when we go get ready either to go to orphan well or through the purchasing or process to get an orphan well plugged. A little difference on this, it's pretty common what we do, maybe something that's a little higher because there's some unknowns in this well. We have that contingency at 20%. I've probably allocated maybe one extra day to complete things, which is not totally out of the norm. And also on this estimate, we have a single well mob cost. And I had mentioned this earlier in the briefing session that those can range from 20 to 30,000 typically. Most recently, I've gotten an estimate from on a well that we plugged this year of 35,000 for a mob cost. So it's pretty high if we're going to use a mob cost for one well. Another thing, just kind of on the contingency side of things, and using the example of the well we just plugged. One day can cost you, $7,000 to $10,000 depending on what kind of work you're doing. We had one issue where we had to drill out a plug that wasn't expected. That ended up costing us roughly $9,000 additional dollars for drill collars that were not expected, and the time and of the rig, etc., for about a 10.5-hour day. So those costs can escalate fairly quickly.
Great. So if the division were to have Mr. Barton's bond forfeited, how much of a shortfall would there be taking into account his $15,000 cash bond?
So based off of this estimate, we'd have a shortfall of approximately $53,776.
Okay, so next let's move to Exhibit E, the permit to drill. Would you please describe this exhibit?
Yeah, this is just the cover page or the approval page for the application for permit to drill for this well, the Academy number 1 well.
According to this report, when was the Academy number 1 well permitted to drill, and when was it actually drilled?
So the approval date was on May 2nd, 2017, which is located up in that kind of the header information on this exhibit. The well was spud on or around May 30th, 2017. I say on or around, we had our inspector out there that had verified that it was drilling at on that date, but there was no spud notice submitted by the operator, so we don't have an exact time or date when that was actually spud.
And are these spud notices required under the rules?
Yes, they are required to be submitted within 24 hours of spudding a well.
What conditions of approval were included in the permit to drill?
You can see that here on Exhibit E, and there's several conditions on there. There's conditions of approval that are specific to this well. And you can see midway through the first page of this exhibit, where the conditions of approval are: surface casing shall be cemented to surface, compliance with the statement of basis. There's also additional approvals, and one in particular that I'll point out is kind of the notices required on the second page, maybe roughly the second paragraph. It's not really a second paragraph, right there, yeah. So within 20, you're supposed to notify within 24 hours of spudding the well, and also doing some other actions on the well bore. That's about the third line up from the top, down from the top there.
And does this permit to drill contain a condition that requires compliance with all of the oil and gas rules?
Yes, it does.
Okay, we'll move to Exhibit K. Would you please describe this exhibit and how it was produced?
So this is a screenshot of our oil and gas website, which is just showing the production from this well in particular, and it shows the cumulative production of this well since it's been since it was permitted, and that is 0 cumulative oil production, 0 cumulative gas production, and 0 cumulative water production.
So according to this report, how long has the Academy number 1 well been shut in?
It's been shut in over 2 years and 8 months.
And it's still currently shut in, correct?
That is correct.
What rules, what do the rules require for approval of shut-in status for more than 1 year?
So it requires a plan for the well, a reason for the well to remain shut in, a showing that the well's got integrity, pretty much a mechanical integrity test showing casing and cement are in good shape, and then gaining that approval for extension.
And did Mr. Barton submit any of this information to the division?
No, he did not. He did not submit that information to the division.
So do these facts indicate, in your opinion, that the subject well has been in violation of Rule 649-336, the shut-in well rule?
Yes, because it's been shut in over a year without division approval.
This concludes my examination of Mr. Doucette. I'd invite any questions from the board before I call Mr. Joshua Payne.
Board members, any questions? We'll start on the right. Brown.
So if I understood what you said at the beginning of your discussion, with a $54,000 deficit, you would intend to make that up through fines?
Yes, we intend, well, that's our basis, as Mr. Payne will testify to. That's our basis for a recommended fine minimum as recommended by the board to the district court. If that makes sense.
Yeah, it makes sense. I guess just from a common sense perspective, though, at what point are there diminishing returns between legal fees and other avenues to get this work done?
Yeah, that's definitely going to take some work on behalf of the AG's office and division staff, and I guess I would emphasize that that's a minimum fine amount that we would seek from the board, and also emphasize that the board, under the statute, can recommend a fine to the district court, but it will ultimately be up to the district court to determine what fine is appropriate in this situation. However, Mr. Payne will testify that the statute authorizes a fine significantly higher than the $54,000.
Thank you.
Other questions on the right? On the left, any questions? Ms. Davis?
We were listening this morning to some bond development, a bond audit this morning. My question is, how was the 15,000 determined, and how is it that it's actually 69,000?
So kind of, as I explained this morning, I mean, a good portion of that is mob cost for a single well. So we're assessing in this estimate roughly $24,000 for mobilization costs. The 12 to 15,000 would be the low end of what we have and what we possibly could plug certain wells for. And the other issue that I'd mentioned in my testimony was we added a 20%, contingency fee on there, and maybe another day or to get the work done to make sure we assess this properly and didn't shortfall our end of those estimates, especially if we go to get a fine, to make sure we get the proper amount for plugging it back into this well. So. And on top of that, we also have in this case, we have some minor reclamation issues. It's pretty flat, I think we assessed roughly $3,000 for reclamation as well. So, we do the analysis based off of the well in particular, and go through the procedure and come up with the number. The 12 to 15 is the lowest that we could ever expect that to be without some of these additional factors in there. So if you do the 15,000, you add a $30,000 mob cost. You're at 45. You add, maybe 10,000 in reclamation, stuff like that. You can get up to that 65. Just for an example, the plug or the well I mentioned we just contracted out and plugged was a little bit deeper than this well. It was bid out at like 56,000. I said we had about $9,000 plus overrun on one aspect of it. The final bill on that was $65,000. So pretty comparable to this. It was a single well. And on that case, we didn't have mob costs because we had a local person doing it. Some of the other bids we got on those were $95,000. So our history has been like in the Cisco wells, as I mentioned earlier, we've had some flat plugging costs in the $12,000 to $15,000 range for certain wells. Some of that information or some of those costs may be a little bit dated, and they're a little elevated now, but that is probably our bottom line cost just for plugging costs.
Questions? Thank you. You can call your next witness.
All right, I'll call Joshua Payne, Compliance Manager for the division. He'll be testifying as a fact witness. Mr. Payne, would you state your name and position for the record?
Joshua Payne, Compliance Manager for the Oil and Gas Program for the division.
As part of your duties with the division, have you helped issue permits and regulate the Academy No. 1 well?
Yes, as part of my duties, I assist and manage in enforcing the rules regarding oil and gas operations here in Utah.
Okay, we'll move to Exhibit G. Would you please describe what this document is and when it was issued?
So this is a notice of violation that was issued to Spencer Barton or Empire Energy. It was on October 18th, 2017. And basically this was issued roughly 4.5 months after drilling for improper well identification. As you can see, no well sign posted.
And when was compliance due under this NOV?
Compliance was due November 16th of 2017.
And was compliance completed by this deadline?
No.
Okay, we'll move to the second page of Exhibit G. Would you please describe this document and when it was issued?
So this is another notice violation issued to Spencer Barton or Empire Energy. It was issued February 28th of 2019, and compliance was required by April 1st of 2019.
And did Mr. Barton comply by April 1st?
No, he did not.
And what communications were you engaged with with Mr. Barton in between these two notices of violation?
So our inspector at the time, between this notice violation and the prior notice violation, had tried to contact Mr. Barton through phone calls, the phone of record that we had on the application of permit to drill, with no success. Basically, Mr. Barton would not return any of the phone calls that our inspector, Mr. Jones, had tried to contact him with.
And why was this second NOV issued? What specific violations were there?
So this notice of violation was issued for an array of things that had taken place from the first notice of violation up to this point. You can see on the first page there's rule references that basically state all the rules that Spencer Barton is in violation of. Shut-in and temporarily abandoned wells, well completion and filing of well logs, drilling operations, on-site pre-drill evaluation, pollution and surface damage control, and then basically the biggest one that I want to point out for this notice of violation is the lack of field presence for the pollution and surface damage control, and then also the length of time that the well had been shut in at this point.
Okay, and with that, we'll move to Exhibit H, which is the division order. So would you please describe this document and why it was issued and when it was issued?
As you mentioned, this is a division order that was issued by me on May 17, 2019. This was basically elevated to a division order since the two prior NOVs had gone unresolved and unanswered. And the process, basically, we give the operator an opportunity to resolve violations through the notice of violation, and after such case, it usually goes to a division order, which in this case it did.
And I guess for the records and the board's information, why are the rules, particularly the shut-in rule and the field presence rules, why are they important, and why is it important for operators to plug and reclaim inactive wells?
So the biggest thing when you get into a situation like this is lack of field presence, which goes hand in hand with the shut-in rule requirement. So when you have a well that sits out there and nobody's out there checking on the well, it can pose a number of hazards. You've got environmental damage that can do to any kind of downstream or freshwater sources. It can be hazardous to livestock. We've seen that in the past, or wildlife. Ultimately, it can be, in this case, being as close to the city limits as it is, it can pose a health risk to the local populace and cause a safety hazard for that. Also can cause problems downhole with other formations or zones.
And what was the ultimate effect and order stemming out of this document, and when was compliance due under this order?
Compliance was required. I can't see it on there. It was 30 days after the date of mailing.
And what type of compliance was to comply with all?
So this order is basically an order to plug due to the lack of field presence and the possible threats that it could pose.
And did Mr. Barton have a right to appeal this order?
Yes, in the order it does give Mr. Barton the means and the direction of what he needs to do if he wanted to appeal the order.
And did he appeal this order? And if not, would you consider this a final agency action?
No, he did not appeal the order, and yes, I would consider this a final agency action.
And did he comply with the order? Did he ever plug the well?
No, he did not.
Okay, we'll move to Exhibit F, which is the August 2019 sundry. Would you please describe this document, who sent it, and what they're claiming.
So this is a sundry for basically requesting to do a nitrogen drop
From
Spencer Barton. I'm sorry, was there anything else that?
so what is a nitrogen drop? What is he requesting?
So that's where we're not entirely sure. It's not a standard industry term that's used, and you can see under the denial portion that it was unclear what they were asking, and also it was denied for the basis that it was under a division order to plug.
Okay, we'll move to Exhibit I, which is another sundry. Would you please describe this sundry?
So this is a sundry in response to the division order, but really in response to the second NOV that was issued. This is basically their drilling report that they listed out on the sundry, and that was one of the things they were in violation of, was failure to file their reports.
And in this sundry, they mention they completed some plugging. Is this the type of plugging that was ordered under the division order?
No, as I stated, this is more or less just their drilling operations during their drilling processes. So at the end there where they talk about the cement that they've, it says at the end, cemented abandoned, they're basically referring to a plug back.
Okay, we'll move to the next page of Exhibit I, which are these pictures that Mr. Barton sent in. Would you please describe what these pictures depict and why Mr. Barton sent in these pictures?
So these pictures were taken after the division order was sent. That, again, basically in response to the division order, but more or less in response to the second NOV, dealing with pits being reclaimed, proper signage being posted, and these were just sent in to show that they had done some surface, basically address some of those things that were in the second NOV.
And did these actions have any effect on the division's order to plug and reclaim?
No, they did not.
Okay, finally we'll move to Exhibit J, which is the October 2019 sundry. Would you please describe the request and why the division granted the request?
So this is a sundry requesting to go out and do a mechanical integrity test sent in by Spencer Barton. Again, this is in response to the division order and also to the second NOV concerning the shut-in rule requirements. The division approved this because whether it's under a division order to plug or not, and mechanical integrity test is always a good thing. It gives us the ability to see what's going on downhole and doesn't affect our decision on whether to leave the division order in standing or not. It's basically just to give us some more headway. For instance, if we do assume the well and plug it under an orphan program, it would assist Mr. Doucette in knowing what is going on downhole and if there's any other problems, and also help him in determining those plugging costs.
And did Mr. Barton ever complete the mechanical integrity test?
No, he did not that we're aware of.
So has the division, just to be clear, have they ever retracted their order to plug and reclaim the well?
No, we have not.
So at this time, has Mr. Barton made any efforts to plug and reclaim this well?
No.
So in your opinion, has Mr. Barton indicated that he is unwilling or unable to comply with the division's order to plug and reclaim, and therefore in violation of Rule 649-3-1.16?
Yes, based on the evidence of what he has failed to do in response to the division order to plug, I would say that he has definitely indicated that he's unwilling or unable to plug the well.
Okay, and with that, I think we'll move to penalties, which might be the most, what the board might be most interested here. Under Utah Code, Section 4611-4A, it states that if the board determines after an adjudicative proceeding that any person has violated any provision of this chapter, any permit, rule, or order made under the provisions of this chapter, that person is subject in a civil proceeding to a penalty not exceeding $5,000 per day for each day of the violation. In the division's request, they request authority to seek penalties in an amount the district court finds appropriate, but the board may, of course, provide its own recommendation of a penalty if they feel it is appropriate. We anticipate that the board might appreciate some guidance in deciding a penalty to recommend to the district court, and Mr. Payne and Mr. Doucette are prepared to testify as to some facts that might help the board in determining if and how much of a penalty should be recommended to the district court. So, Mr. Payne, why is the division seeking penalties in this case?
As stated earlier, we're basically just seeking the minimum amount to ensure that we have the money required to plug the well, which is clearly going to be above and beyond what their bond has, basically, so that we don't go, have to go seek additional outside funding.
And under the statute, what is the maximum penalty the district court could issue to Mr. Barton?
So based on this being in violation since essentially May of 2019, the court could, in all essence, issue a fine in excess of $1 million.
So what dollar amount would be adequate to ensure the division does not have a funding shortfall if it were to contract to plug and reclaim the well?
That's where we're requesting the estimate that Mr. Doucette came up with of $68,776.
So factoring in, as Mr. Doucette said, the $15,000 cash bond, what would the penalty request be?
To take the $15,000 cash bond out, that would leave the penalty in the amount of $53,776.80.
And to be clear, is this a minimum penalty the division's requesting?
Yes, this is the minimum penalty.
So that concludes my examination of Mr. Payne, and at this time we would, if it's appropriate, move to admit the exhibits and then open it up to questions.
So, before we do that, let's have the board ask its questions and then admit the.
Okay.
Mr. Brown.
I'd just like to clarify penalty clause here. It says, in a civil proceeding to a penalty not exceeding $5,000 per day for each day of violation. Typically, I see things like exceeding $5,000 per day per violation for each day of violation. How many violations did he actually have? It wasn't just one violation. There were numerous violations cited. Not that it changes the estimate or the fine recommendation, but is it in fact 5,000 per day violation?
I guess I could speak to that. It could be considered that there are multiple violations. There's one single agency final agency action stemming from the division order to plug and reclaim, but that adopted the underlying 6 or 7 violations. So, in essence, the district court could find that each of those violations could qualify for $5,000 per day. So, there could be a substantial fine if the district court found it appropriate.
Thank you.
The questions on the right, questions on the left. Mr. Borden.
This is more of a tactical question. Do we know if Mr. Barton would even have the resources to pay a penalty of $54,000 after you go to all the trouble to take him to court?
It's a difficult question that I can't answer surely, but since it's in his personal capacity, as long as he's around and doesn't file for bankruptcy, we can go through the typical collection process that the court affords, and if he doesn't pay the fine before or after the court order, and the collections process can do tax garnishments and things like that. But that's a difficult question, and we feel that the shortfall is significant here, and we want to try to get the money as soon as we can to ensure there isn't a shortfall.
Thank you.
Other questions? Pardon me, I have a couple. Let me tell you where I'm going first, and then ask my questions. I'd be interested to see how our process as it currently exists would have either changed or remained the same had it gone through what is before the legislature today as Senate Bill 148. What would we have had to do differently? We've had a hearing. I think the bill requires an opportunity for cure,
Correct.
as they call it. If the process is in fact basically exactly the same, but for going to court, I'd like to know that. That's just an aside. And I'm wondering if it would be a labor-intensive endeavor to just examine the record in this case as against what the new statute, if the bill were to pass, this Senate Bill 148, pass the legislature. And I'm wondering if that could be instructive to the board. And so what I'm suggesting is a letter to the board of just what would have to have changed or what would be different.
Yeah, I think
That's my first question.
we'd be happy to draft that, and just, initially, I think one of the benefits of the proposed legislation is that it would allow us to get in front of these problems before they get to this point. The first violation of not having adequate well signing, we could at least have a real power to threaten a fine, which, would get him in line right off the bat. And then when the more serious violations came in, we could, have real enforcement power without having to drag this on and then eventually go to district court.
Okay. And the second part of my question has to do with legal fees. As we're basically going through a full-blown adjudicative proceeding. Is it the same as if you went before a judge? What would be the duplicated legal fees and witness time, as best you can estimate it? Assuming, I'll just throw this out, say $50 an hour.
Oh, that's again difficult to determine without seeing how this process would play out. It depends if Mr. Barton defaults again at district court. That could speed things up, but presumably, if things it could turn into a full-on, adjudicative proceeding in front of a judge that would have significant time coming from the AG's office and division staff.
Would it be in the range of 10,000, 15,000, 20,000?
I don't think I can speak to that. I think it's, significant hours, I think.
I think in my experience, it would be no less than 10,000.
Yeah, definitely weeks of extra time on top of all the other work that we do to keep the legal.
Was 10 or 20, if you say it's weeks. And what I'm suggesting, and what I want to look at from my perspective, is this sum that has been for plugging the well in the range of $69,000, plus the time to go from this hearing and start the whole process over again in a trial court. And so an estimate of that, but assuming otherwise, I think something in the range of 15. My personal experience would be 10 to 15 to 20,000, splitting the difference, say 15,000.
Yeah, I don't think that'd be unreasonable.
Would you respond to that if 15,000 plus the cost of the well be a reasonable recommendation to give to the trial court?
I think that would be reasonable considering, the costs of bringing lawyers and staff all the way up to district court.
Anyone want to respond to that, or anyone have a feeling about that? Okay, let's identify the exhibits that you would like to have entered. I have A, C, E through the end, which is Z.
E through L and then Z.
I have, the ones you haven't admitted are B and D. Is that correct?
That's what I have.
Board members, any problems with admitting those exhibits? Seeing none, exhibits A, C, E, F, G, H, I, J, A, L, M, Z are admitted. Okay? And so at this time, we would like to, board members, we can either, I think what's before us is the dollar amount. Is that correct? Or is there another part of this order that we need to consider?
The order, we're requesting an order to forfeit the bond to plug and reclaim, and the authority to plug.
So you got the forfeit, and then you got a dollar amount. Is that correct? Is there anything else that should go in this order?
And just sorry.
You're going to write it, so, you know.
I'll just, so in my closing I have prepared is the division requests an order that forfeits the $15,000 cash bond and authorizes the division to use the funds to plug and reclaim the Academy Number 1 well, authorizes the division to file an action in district court to recover penalties and enforce the terms of the order, and grants any further relief the board finds appropriate.
Board members, do you feel like you understand all that? Okay. Thank you for that. Board members, would you like to discuss this in the other room, 1010, for a minute? Okay. We're going to take this under consideration and to discuss it in chambers.
Thank you.
So at lunchtime, how do you want to do this? Do you want us to, so I emailed how's this guy? Did you switch him? He just played. You worked back with people's homes. So this state, it's just a webinar to listen in on. Okay, so there's just, I just turn it on and listen to it. Yeah, and then there's sometimes like a little text box, you know, type comments in, and like a question.
You guys know that when I did it, that was kind of the first time I was exposed to climate justice. Oh, yeah. Get a definition.
We just texted. Oh, you just did? Okay. Yeah. I was like.
low profile. And at the same time, it sits so low that it's sometimes hard to see it.
I know. Yes.
Probably just it's a lot of stuff. I have no idea. Do that. Grab some water. Yeah, I don't know if he's it's because we
Yes.
go.
For the sake of using, so they did justify their existence.
Watch what's in there. Yeah, it's good. Yeah, Super Tuesdays is basically like a big states all both at the same time. So right now, South Carolina is this Saturday. It's that relaxation. So all of these kids are voting on Tuesday. So it's like Tuesday because it's big for us. For the
Yeah.
is that that's true division? Actually, there is two. Actually, right? That's true division. This is division. Last time I was going to election ballot. This is his responsibility. For all these ones? One or the other. And some of these people could be like these are no independents or independents. No, that's
Okay, we're back on the record in the matter of Spencer K. Barton. We've deliberated it, and I believe Ms. Davis has a motion.
The Board of Oil, Gas, and Mining makes a motion that the division proceeds with the plugging, abandonment, and reclamation of this well using the proceeds of the $15,000 cash bond, plus seeking the additional monies required to complete the job, which is, according to the estimates, $53,778, plus authorizing the division to seek penalties of $15,000 in district court.
Is there a second to that motion?
Second that.
Any discussion of the motion? Is the motion clear to council?
Yes.
The motion before you is to grant the motion of Susan for forfeiture of the bond, additional funds, and an administrative penalty recommendation to the court of $15,000. All in favor, say aye.
Aye.
Any opposed? The records show that that was unanimous. Mr. Rowe, will you prepare the order?
I will.
And then the letter is just, the letter to the board analyzing Senate Bill 148 is just administrative. It has nothing to do with this case other than our education.
Great, thank you.
Just, you don't need to have that part of it in the order. Board members, we have about 25 minutes before our scheduled lunch. I think that may be all the time that we need to go to the last agenda item, which would be agenda item number 6. And what we'd like to do is talk about the rulemaking. Let's see, no, pardon me, is it that the? Yes. So that we're clear, we're going out of order on to agenda item number 6. I'll read that into the record at this time. Council, take whatever time you believe is necessary. We are on docket number 2017-013, cause number RONG-2017-01, in the matter of informal rulemaking associated with the 2017 and 2018 legislative amendments concerning forced pooling and the need to initiate rulemaking on other emerging issues, including but not limited to rulemaking on operatorship designation. Just one procedural matter. There's been a request by an attorney by the name of Tony Hunter to testify electronically. That motion is granted. And my understanding is that he is now electronically connected to this hearing. We'll start with appearances of counsel.
Thomas Kessinger, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Gordon Rowe, Assistant Attorney General for the division.
Fred McDonald on behalf of the Utah Petroleum Association and EP Energy Company, LP.
And Mitch Mayo here on behalf of XCL Resources, LLC.
Okay. Is Mr. Chicken still in the audience? Because I believe he was interested in maybe making a comment. Would you like to reserve the right to make a comment or not? I couldn't hear that. No.
I believe he said not for this rulemaking, but possibly for the other one.
Okay. Well, we're going to be discussing these in order. We're going to start with the pooling rulemaking, informal rulemaking, that is whether it's ready to go to formal rulemaking. We'll then go to operatorship rulemaking and informal rulemaking, whether it's ready to go to final or formal rulemaking. And the last is what we call the horizontal rules, or some people have called them the well siting rules. For the purposes of this hearing, we'll call them the horizontal rules. So there's 3 sets of rules that we're looking at. I believe I can expedite matters by taking the last first. It appears to us that the rulemaking on horizontal drilling still needs a little more time and vetting. So it's the intention of the board not to go to formal rulemaking on that.
Chairman Gill, sorry to interrupt. Mitch, did Mr. Hunter, you said he's on the call. Did he identify himself and the party he represents?
I beg your pardon. I didn't hear him say anything. Mr. Hunter, are you on the call? He had requested, and I'm going to put it in that he is, just so that all people know, he is intended to be on this call. We may have cut him off. So we'll wait till we see what happens.
Hopefully that cleared it up.
Hey, Mr. Hunter, you're involved in this case, is that correct?
Good afternoon. Yes, I've requested to appear electronically, and hopefully I'm appearing electronically.
Well, by granting the motion, it was the same as accepting his appearance of counsel. Okay, are we clear on that? Thank you. So on the last one, board members, as to what we're calling the third set of rulemaking on horizontal rules, we are not going to take a position on that today and allow those to continue in the informal rulemaking process. Anyone have concerns or problems with that? I'm going to take that as no action is required. They will continue in the formal. So let's go now to the first part, the pooling rules. The pooling rules, we have had numerous hearings, a lot of evidence, and one of the things that really assisted the board was that if there was a question, concern, objection, we asked the party proffering that objection to give us remedial language that would solve the objection, what it would look like. And that has been very, very helpful. The board, I believe, or at least I'll speak for myself, that we're at the point where on the pooling rules, they've been sufficiently vetted. We've had, I think, 4 to 5 hearings on it, and it should be ready to go. We asked Julianne to submit to the board a final draft of it so that there was no question. Board members, you should have received that the middle of last week. And so the question is, should we move forward? So what we'd like to, on the pooling rules, and to go from informal to formal, we're going to start with Mr. Kessinger and then just move our way down to the council
Chairman Gill, thank you.
Get whatever input you would like to give us.
Thank you very much. Comments from the division regarding force pooling, the force pooling rules are very limited. I think I agree that they have been thoroughly vetted. There has been numerous hearings on this topic, and though the force pooling rules will have a significant interaction with operatorship and the horizontal rules, the division believes that it is okay to move ahead with formal rulemaking.
Mr. McDonald.
Thank you, Mr. Chairman. After the November hearing, we had a conference call in January between Board Counsel, Division Counsel, myself, and Mr. Hunter, trying to work out some issues and to understand exactly what the board's direction was from the November hearing. We had the sense that the board wanted to move away from the payment of dry hole costs, and so, but the indication was there would be acceptable to try and put the parties in the same position with respect to remedies under a AAPL joint operating agreement. So the version that UPA submitted to you incorporated those concepts. It agreed and eliminated the requirement to pay up front, but the rule now, as proposed, adopts the provisions of Articles 7A through D of the 2015 AAPL Form 610. It states that those are deemed just and reasonable and would be incorporated as part of any board order force pooling. I think that remedied at least the best we could to come to what we believe the board had indicated through those discussions. The provisions were also provided to you as part of the rule, although I don't know that they're necessarily going to be incorporated in the rule, so that you could read through those remedies. So we would ask that the board go ahead with formal rulemaking. We agree with the division that we believe that these rules can be adopted separate from the operatorship and the horizontal rules, although they will be tied together. I don't think that the issues from the force pooling proposals are so dramatically tied to the other two rulemaking that these can't be adopted as UPA submitted them.
And also, I think for the record, the board is continually asking itself, even when we get it right, how could we have done it better? We're always looking for improvements, particularly continuous improvement, methodology, and so I think that plays into where we've gone. We've given this a lot of hearing, a lot of vetting. It's an improved process, and it's an improved results. Mr. Mayo, would you like to comment?
Yeah, briefly I would.
Closer to the mic, Mr. Mayo.
Thank you. Sorry about that. Briefly, I would like to comment. First, just to agree, I think these rules are discrete enough and distinct enough from the other rulemaking package that these can proceed to formal rulemaking without waiting for those other rules to be brought up to the speed this one is at. In addition, I'd also like to note there's kind of a practical reason for moving these on, and that is that this statute has been in place for 2 years now, and operators will be drilling, if they have not already, additional wells on these drilling units that have been force pooled. Put another way, the statute is in effect, and operators, as we saw, are starting to drill more and more wells on these drilling units. Those wells will, as I read the statute, be force pooled if a well has been force pooled on that spacing unit. All these additional wells will, per the statute, be force pooled as well, unless and until there are these additional rules in place. And so to the extent the board is concerned about protecting everyone's interests in this, I think advancing these rules is really the best way to do that, because it sets up safeguards, imperfect as they may be, it sets up safeguards to basically implement that statute. So that would be my comment.
Okay. And Mr. Hunter, you're on the screen.
Chairman, yeah, I agree with Mr. McDonald and his comments. I think it'll have the additional benefit of giving us a sort of an anchor to analyze the horizontal siting and the operatorship rule against if we're relatively certain that this is the pooling and compulsory pooling rule that we're going to be working with. So I think with that, I may still submit some comments about some things on the edges, but I think it's ready to be submitted.
I'm going to bring it back to the board then. Is there anyone else in the audience that would like to comment on this that is not represented by council? Okay, board members, the proposal before you is to take the pooling rules as in the final draft that Julianne, I believe, or Mike Begley sent out last week. I believe copies are available. That go from informal to formal rulemaking. I don't know that we need a motion. I think I just made it. Is there a second to that motion?
I'll second it.
Okay. Any discussion of the motion? All in favor? The motion before you is to send the pooling rules from informal to formal rulemaking. All in favor say aye.
Aye.
Any opposed? Let the record show that that's unanimous. Okay, we'll move to the second portion of the rulemaking. Has to do with operatorship. You also, board members, received a copy of that proposed operatorship rule. Ms. Davis made a suggested addition to it, which I think that all of us in the board agreed was a good addition. So we know what version is before us. Let's go to you, Mr. Kessinger, for comment.
Thank you very much. The division has hopefully a brief presentation about operatorship rulemaking. I'm going to be asking John Baza about some of the comments that he's received from Tony Hunter and his consideration of those comments. And ultimately, the division is not prepared to move to formal rulemaking with the operatorship rules at this juncture. There is significant interaction between the operatorship rule and the horizontal rule, and the division has taken a number of steps to formalize their position on the operatorship rules. But there's still enough unanswered questions that we think it could benefit from one more month of careful review. So I'll move to my next slide here and just ask Mr. Baza about the letter that he received from Mr. Hunter. Mr. Baza, did you receive a letter from Mr. Hunter?
Yes, that was transmitted to me by electronic mail.
Mr. Baza, will you get a little closer to the mic, please? I'm not picking you up on it being recorded.
Excuse me, Mr. Chairman. Yes, Mr. Hunter's letter was transmitted to me by electronic mail.
Thank you. And I'm going to show you this slide. Is this just a brief overview of the comments that Mr. Hunter raised?
Yes, I believe that summarizes the 5 points from Mr. Hunter.
And do you want to speak to each of these individually, or would you prefer that we just move to the suggested language?
I think that Mr. Hunter needs to probably address some of these comments during his statements on the operatorship rules, but I see the 5 points as being, number one, a self-designation of the operator, a concern that is expressed there. Preparation for drilling is point number 2, and point number 3 is permit revocation. Point number 4 is permit protest, and point number 5 is permit considerations. And we can probably move to the division's comments on those various points.
Okay. So in terms of designation of operator, The division is suggesting that the rule as drafted allow for the self-designation of an operator to be afforded to an owner who has a 70% or more interest in the drilling unit. Do you want to explain why the division is taking this position?
Well, I think in speaking with Mr. Hunter verbally by phone over the past week or so, I think there is a concern about having greater than 50% be the cutoff for deciding how the operators are designated. I think there's substantial reason to say there could be some close calls that come out of that. For example, a 50.5% interest versus a 49.5% interest. The division does have a unitization statute that they have to follow for example, secondary enhanced recovery unit that requires a 70% working interest in order for the board to designate a unit under that statute. As a first cut, we think that 70% probably represents a good number, although we don't have any scientific basis for that. We do believe there's precedent in statute to be able to use that number.
Thank you. Moving on in terms of the self-certification and what that self-certification should look like, Mr. Hunter raised a concern about the weight of the evidence or the evidence that would be submitted by an operator to qualify for a self-certification. The division is recommending that self-certification be evidenced either by an affidavit or a declaration in conformity with the Unsworn Declaration Act, just so that it is clear as possible. And do you want to speak to why the division is moving this direction, or would you prefer that I speak to that?
Let me just say that maybe summarizing the explanations you've got on the page, the division right now does not have landmen working for the division. We don't have really the ability to go out and search title or examine title, or even, frankly, to understand what a title report that would come from an attorney would describe. So I think that we really worry that without having some ability for the operator to self-certify through some kind of affidavit or declaration, that the division doesn't have the resources to do that. That's probably the biggest reason. Maybe, Thomas, you'd like to cover the other items.
Yeah, and then I want to discuss this idea of burden shifting and why the burden is shifting to the non-applicant owner to prove that the applicant owner did not have sufficient interest. Again, it comes down to the division does not have the ability to independently examine the title, and so with an unsworn declaration or affidavit that's given under penalty of perjury, we feel that's sufficient. That evidence is of sufficient credibility for the division to make an initial determination, and then it's up to the other owners in that unit to protect their interest. And so we think this is a permissible shifting of the burden. And so this next slide, this is discussing the notice. Under the UPA recommendation, notice was to be sent essentially just posted on the division's live data search website. The division isn't opposed to having a website that tracks this information, but given the interest at stake here, the division thought that additional notice by mail would be more protective of other owners' interests in a DSU. Do you have any further comments on that?
No, I don't think so.
All right. And then finally, this is again going to notice and the ability of a party to contest the approval of an APD. 10 days was too short of a window for the division to feel comfortable that an interested party could sufficiently protect their interest, and the division recommends 30 calendar days to be able to protest.
Before you leave that one, are you saying that you would not use email or electronic mail? Could you use both? as an option?
The way that the text reads now is it requires the applicant owner to provide notice of the APD approval by mail, as
And that's
well
fine, but-
as well as on the division's website. So if whichever 30-day notice expires later would be the effective one. So if the division gets it on their website after day 1, but mail doesn't happen for 7 days later, then you'll have 30 days from mail, vice versa.
Okay, thank you.
So in conclusion, I think the division is comfortable with those suggested changes. And again, we're comfortable moving forward with the rulemaking on the forced pooling rules, but we stress that operatorship and horizontal rules have not taken their final form. I think most importantly, the division would like to be able to control this process for 1 month longer to ensure that the debates we heard in formal rulemaking in the forced pooling rule matter does not occur. We think there's tremendous efficiencies that can be gained by continuing to workshop these rules internally and prevent any divisiveness from occurring. Thank you.
Mr. McDonald.
For the record, Mr. Chairman, I'm representing both the Utah Petroleum Association and Ovintiv Production, Inc. on the operatorship and horizontal rules. What I'd like to say is, first of all, this is the first time we've seen the division's recommendations on this. So we're not in a position to discuss point by point the issues that have been raised. UPA members, at least initially, felt comfortable with the rules that were submitted and were vetted by its membership and would go with that. But we're not in a position to go point by point today. With that, I'll turn the time over to Ms. Renko-Brown.
Hello, Ricky Renko-Browning, President of the Utah Petroleum Association. We appreciate the work that we have been able to undertake with the division on both of these rulemaking processes. But as Mr. McDonald just testified, this is the first time that we've seen this feedback from the division. These are positions that differ from the position that our common membership has had a unanimous position on, and we're not in a position to be able to either confirm or provide an alternative to any of the points raised here today, and we will need to go back and discuss with our members before we are able to do so. That being said, we do agree with the division that it makes for a much better final rule if we are able to address these sorts of issues and concerns through an informal rulemaking process, and we support the proposal to continue forward in that manner. The one other point I would like to make is that the division has brought up both the operatorship rule as well as the horizontal rule as a sort of package, perhaps. While there certainly is an overlap of concepts and principles, and the two do interplay with one another, from our opinion, we don't see a need for those to move forward simultaneously, and would be very comfortable moving forward with the operatorship rule ahead of the horizontal rule, if that's helpful in terms of timing considerations for this board. Thank you.
Mr. Mayo?
Just to echo those comments, most notably that I think the operatorship rule is capable of advancing independent of the horizontal rule, despite any overlap that may exist.
Mr. Hunter?
Chairman, I will echo the comments of the previous speakers, and I'd also say that the operatorship rule going in sequence is probably a useful procedure at this point, mostly because once we get to the citing rule, if there are inconsistencies or vulnerabilities in the previous two rules, we might take the opportunity to correct those prior rules or adjust them based on the final overall picture that we get from seeing how these three rules work together.
Anyone else in the audience like to comment on the operatorship rules and whether to go forward or with formal rulemaking, or whether to give this another month? Seeing none, we're back to the board then. Mr. Moon?
So, a division, what would you envision happening over the next month that would, what would you have happen?
Well, I think you've heard from the other parties that this is the first time they've seen the division's language. And frankly, these language changes were only crafted probably in the last 48 hours. So we really didn't have the opportunity to vet these as well as we would want to. I think that's the first step, is now that this is out out for everybody to see, we'd like the parties to comment back to us. And again, retain some control at the division level on how we respond to that, how we see the rules taking shape over time. But as Mr. Kessinger has indicated, another month would certainly help us in that process.
So these draft rules have been distributed widely. Who have you, pretty sure you're casting a wide enough net to make sure we don't have last minute?
Well, I think we've contacted the parties that have been interested and involved in the forced pooling rules over time. We have not cast a wide net. We've not publicly disclosed copies of the rules that have been developed to this date to a lot of other individuals. I think it's basically the people that are sitting here in this room or on the phone call today. But I think that gives us a good enough feedback that we can craft some language that would be acceptable to at least this group. And I'm assuming that that's going to take care of 3/4, 80% of the concerns that are out there.
There is no requirement in informal rulemaking to publish a draft. Is that correct?
No, there is not.
Okay.
And in fact, informal rulemaking is exactly that. There are no procedural guidelines to how you conduct informal rulemaking.
Okay.
Go ahead.
Ricky has a.
Can I make an additional comment to that?
Please.
So on behalf of UPA's perspective, when we were working through the forced pooling, we did have some differences of opinions between our members. We were not in a full consensus or unanimous position. On the operatorship rulemaking, we have had very strong participation across our membership, and we were at a full consensus position on the rules that we brought forward. So although it's just me sitting in front of you today, I can assure you that our upstream members, which are not every producer in the state most certainly, but a very significant majority of them have been very actively involved in the rules so far.
Anyone else want to comment on that portion of it? Board members, I'm going to take off my chair hat for a minute and just speak as a board member, but I feel very strongly that we need to give guidance on the 50%, 70%. Proposals. In a company that has shares, greater than 50% controls the company, whether it's a public or private. In most of the oil and gas operations I know, particularly federal units and federal operations, it's generally greater than 50% is the operator. So in state units where it's the state law that Mr. Baza mentions, it is 70%. But I think that's a little bit of an apples to oranges comparison, with all due respect. I don't mean to that, but that that if that's the only evidence that we have, then we should consider that. So I'm asking each of you, in your own personal experiences, have you gone to a supermajority? Normally in the legislature, a supermajority is 2/3, which is less than 70%. Any thoughts or feelings on that? I'd like to just kind of take a straw poll for just a second and then see if anyone has strong feelings on it one way or the other. Mr. Moon.
Well, I don't yet. I'd like to hear the discussion and the debate about it. I have heard UPA talk about how it is apples to oranges, and I understand that, because with unitization, you're asking for a serious buy-in. Although declaring an operator is a big deal. It's a really big deal, and so I'd just like to hear more discussion about the risks of it being as low as 50.1% or whatever it is. So that's where I'm at.
Anyone else have? Guidance on that.
Rather than guidance, clarification, when we're talking about self-designation of operator ownership, we're talking about control, so the ownership and other parties have agreed to that majority. Is that correct, or just the individual?
It's kind of a rebuttable presumption, isn't it? Kind of, I mean, it's
assume.
not binding. It is the first indicator that you are in a position to be the operator.
Yeah, it's
And
you
then
plus, you plus those that are
Plus
in
those that
agreement.
agree with you.
Right.
Anyone else? Mr. Borden.
Not speaking from any experience in this issue, but the 70 number does seem fairly conservative. You could see how a 60-40 type number would probably get you out of those gray zones right around the 50% number. But I really don't have the information to pick a number today.
Yeah, I'd like to hear, why maybe a 60-40, something like that, so you're clearly over the 50%. Why that would be why, yeah.
If I could,
Mr. McDonald.
If I could address that, at least on this particular situation. The statute cited with 70% is compulsory unitization. That's for everybody. So that's why it's a high percentage, because you're compulsory unitizing everyone, and they have to buy into that. Operatorship is a separate thing. And the situation here actually is, if you go higher percentages, you're making it harder on a minority interest owner to take over control. And the other factor in all of this, and the rules are, if somebody wants to challenge it, they have the right under the rule to challenge that, whether it's the percentage, whether it's because that operator has a history of overcharging. It's not that they're denied the opportunity to make the case to be the operator versus the person who certifies it. So the due process is protected here all along. So the idea was to make sure that you had more than just 50%, so you didn't have the shotgun of 50-50. But if you reach over that, then that party should be the initial party to be able to control operations. It doesn't deny anybody the opportunity later on to challenge that. And that is the apples and oranges argument with the 70%.
So just to be clear, and Mr. McDonald, can you take just 1 minute to describe kind of how this plays out in your view?
Okay.
So if you're greater than 50%, you have the rebuttable presumption to be an operator, and then take it from there.
Yes, okay, and then you would self-certify.
From the perspective of someone with less than 50, greater
Yes,
than 50%.
okay, it's either that you own outright more than 50% of the unit or the well, or you have an operating agreement if you're under 50%, but you have people who have joined and said, yes, we want you to be the operator. That person is presumed to be the operator. There is an opportunity then to challenge under the situation if you believe the numbers are wrong, or if there are other elements, such as the operator refuses to drill when you have a lease expiration, or if there are other reasons that you can justify to the board why that person or that entity should not be the operator. So it's a rebuttable presumption, but the onus is on the non-operating party to bring forth the justification why that party who is self-certified should not be the operator. So the due process is all in check with it. So, and again, I'm just trying to address that based on the discussion that we had today, that the division has brought this up, but I think it's important for the board, if this is a guidance that you're trying to suggest, you need to understand where that 70% came from and why it's in the statute for compulsory unitization, and also to understand that the rule that was proposed does protect due process and does allow people to challenge that.
Any other comments from anyone on the 50-70% part of it? I'm really
Mr. Chairman, I have
uncomfortable
a
with 70%. I just have to, I'm not asking, this is not a vote. Oh, Mr. Hunter, go ahead.
Hi. Thank you, Mr. Chairman. Just to key off of what Mr. McDonald said, there are differences between compulsory unitization and operatorship, but part of the difference that might make it an apple-flavored orange is that what you're doing is conferring rights upon one party who is similarly situated among many. The variation of ownership differences, whether or not you have coalitions joined to get you over the 50% threshold, how many of these people have been are unlocatables, If that's a significant infraction, how are we counting those people? A supermajority of some kind, whether it's 70% like the unitization statute or some other number, 2/3, 60, whatever, clears out those edge cases and gives the division, an administrative agency that's not engaged in fact-finding or title examination, some assurance that those edge cases are not going to be coming into play on a regular basis. There are plenty of times when a 50% majority is not only sufficient, or 50-50 split would cause problems, be sufficient to cause a problem, but clearing that with some additional percentage just gives the administrative agency a little bit of breathing space to say, this isn't one of the edge cases. And we can comfortably designate that operator without taking on some additional risk that the burden shift from the applicant to the protestant isn't justified. Because as we all know, when you're asking for something from an administrative agency, you have the burden of proof to show that you've met that. The self-certification, I think, is weak, but that weakness is overcome by self-certifying to a supermajority interest that would be difficult for a protestant to overcome.
Thank you all for indulging me on that issue. So we're now back to what should we do? My sense is that we continue another month in the informal process. It doesn't require any action, that we would be granting what the division's requesting. But be clear, the members, the ones that are drilling wells out there in Utah have already said, we're good with this. And so I would put great weight on that, at least in my vote, and ask you to consider that as well. So, all in favor of continuing informal rulemaking on the operatorship rules, say aye.
Aye.
Any opposed? That was unanimous. Thank you very much. Thank you, everyone, for being involved. Mr. Mayo, for the record, who do you represent? Or are you just here speaking on behalf of yourself as an attorney?
At this rulemaking hearing, I'm here representing XCL Resources, LLC. They're the successor to Axia's interest.
Okay. Thank you very much.
Chairman, did we officially say we're not advancing the horizontal well rules as well?
Yes.
Okay.
Yes, we did that. So just to be clear, we have gone in terms of the pooling rulemaking to formal rulemaking. On the operatorship, we are continuing that for a month. On the horizontal drilling, we are continuing that until we're satisfied that we have vetted that and have some proposals before us that are okay. So anyone feel like they want a different conclusion than that? So the proposal is that in the March hearing, we will again discuss operatorship going to formal. If the horizontal rules are also ripe enough for that, we could look at those at the same time. Okay. Thank you all. Appreciate it. We'll now break for our scheduled lunch.
Thank you.
You guys ready for lunch?
catch up with Brink about Paul.
Paul? You want to go Paul?
They gotta try Apollo anyway.
They've never put it on a pastrami burger. They gotta try.
So these are the ones we want. We want the OGM board. So it isn't the desktop, so we're gonna look for the OGM board. Is that the one? Right? On yeah. So open that up. So there should no objections. Will be that whole period will demonstrate. After lunch break. That's the whole. Yeah. So I usually drag that one and drop it in the stills. So now I have it over there. So now the key to get it off of there. Shift. So here's our media players. So you're familiar with shift. So here's our media player. That's your number one. So I'll put it on. Deck, right? But then what we do is you kind of move this forward. After transition, but you leave it halfway there.
I would suggest like usually like 1:10 somewhere around there. 12:19. You can put them up at the front. I'll watch them. I'm saying I'm gonna watch them. You don't want to watch them.
The important thing.
Just leave it on.
Okay. Yes. Yes, ma'am. Thank you. Okay. So that's pretty much it. And then sometimes what I'll do is I'll cut all these yours. I'll pull this back down. Change the pixels. Forward, change the pixels, and then YouTube won't cut us off. Yeah.
I didn't know if they were, and I haven't been involved in it, but, well, I told people when I'm kind of in a unique.
So how do you feel with the board?
Pretty good. So I don't have
Just a little muscle memory is what you need. Yeah. It's good. Play video games?
Worried about time.
Yeah. It's just like one of those things, like,
If we need to
you
go back.
get to like, you're like in it. Look after one. But yeah, I typically when I have someone in 1, 2, and 3, I'll just leave my 1, 2, and 3 fingers like that. I have cameras 1 through 4. I don't even have to look at it. I've got my muscle memory built into it. So it's pretty good. Let's actually go over here.
Slightly.
Do you want to? Let's see right here.
Enjoy.
around doesn't.
Council, could you, before we go back on the record, let me know if you're ready to proceed, how much time you might need? You're not active, Tom. We don't have the mics working on this level. Can you guys hear me okay?
Check, check. The mics are working now, Mr. Chairman, and the division is ready to proceed.
Mr. Chicken, is your mic hot? Negative, yours isn't hot.
You got to turn the mic on itself.
This?
Need to see a green light. Just check it again.
We're good.
And if you haven't testified here before, we ask you to talk closely to the mic because it's all recorded, and we have a dual system here of a court reporter plus the recordings. Okay.
Ready?
Board members, you ready? Okay, we're back on the record. We're going to go to agenda item number 2, docket number 2020-001, cause number 470-01, in the matter of Finley Resources. There's been a motion filed to continue this matter, and the motion is granted, and it's continued to the March hearing, regular scheduled March hearing of this board. And we're on to agenda item number 3, docket number 2020-02, cause number 600-01, in the matter of CH4 Energy Finley LLC. Take appearances of counsel at this time.
Brent Chicken on behalf of CH4 Energy-Finley Utah LLC. Applicant.
Thomas Kessinger, Assistant Attorney General, Division of Oil, Gas, and Mining. Gordon Rowe, Assistant Attorney General, Division of Oil, Gas, and Mining.
Anyone else involved in this case? Seeing none, I would like to identify what witnesses you will have today and get those witnesses sworn. And would you please identify which ones will need to be qualified as experts?
Certainly, Mr. Chair.
A little closer. I'm not picking you up on the
Sorry.
mic.
CH4 Finley is going to have 3 witnesses today, one for land matters. That will be a fact witness only, and that's Ms. Deidre Stoley, and she is a senior landman with CH4 Finley. The second witness will be a geology witness. That is going to be Shay Atkins. He is the geology manager, and Mr. Atkins is joining us by Skype today. He may be a new dad at any moment, so we let him stay at home just in case that happens.
Congratulations.
And our third witness today will be providing engineering testimony, and that's Mr. Patrick Porter, sitting to my left, who is CH4 Finley's reservoir engineer and manager. Both Mr. Atkins and Mr. Porter
have testified before the board in the past and have been qualified as experts in their respective areas of expertise, and we would be asking for the same expert qualifications today, and the board is obviously free to voir dire either witness as to their qualifications.
Division, what witnesses do you plan to call?
To the extent that the division has any witnesses, I would call Ellis Peterson and Dustin Doucette.
Okay. Let's have all of the witnesses be sworn in at this time. Mr. Atkinson, are you aware that pardon me, is it Mr. Porter electronically?
No, Mr. Atkins. This is Mr.
Mr. Atkins, okay. Mr. Atkins, are you aware that you're going to be sworn at this time?
Yes, sir.
Okay. Court reporter, if you swear in the witnesses.
If you'll raise your right hands, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Okay. Let the record show that I saw all of the witnesses here and electronically say I do. Okay. When we get to the division, we'll have you qualify your witnesses if you need to. Mr. Chicken, if you would qualify your witnesses at this time.
I would like to move that, based on their prior acceptance as expert witnesses in the areas of geology and engineering, that Mr. Shea Atkins and Mr. Patrick Porter be qualified as expert witnesses for purposes of today's hearing.
Division?
No objections from the division.
Board members? Seeing none, then they'll be so admitted.
Thank you, Mr.
For the purposes of this hearing.
Thank you.
And then, Mr. Chicken, if you'll proceed.
Sure. This particular request is actually pretty straightforward, but I want to kind of draw a picture so the board understands where we're coming from. Back in 2015, Newfield, now Encana Ovintiv, obtained Order 139-134. And in, well, roughly a year ago, Crescent Point Energy obtained Order 139-158. And we're going to ask you to amend both of those today, and I'll tell you what they do right now and what we're going to amend, and then we're going to put on our testimony. Orders 139 and 139, 134, and 139, 158, I think you can just treat these collectively because they cover roughly the same lands. It is 7 1,280 acre DSUs. They have up to 8 vertical, directional, or short lateral wells, up to 17 long lateral wells in each one of those 1280s, with 330-foot north-south, or we'll refer to them for purposes today, heel-toe, but these are north-south orientation, right? Boundary setbacks for the horizontal wells. And the companion order, the 139-158, established 5 2,560 acre DSUs for drilling of up to 3 long lateral horizontal wells. So these are our governmental section line wells units, and those have those same 330-foot north-south heel-toe setbacks. And the request today is to amend those 2 orders in very specific but limited ways. We want to amend Order 139-134 to increase the density for vertical and directional wells, not for horizontals, but just for vertical and directionals, up to 32 vertical or directional wells, which achieves that equivalent of 40-acre spacing or 2 wells per 80 acres, however you want to look at it, density versus raw numbers. And the second thing that we want to do in amending these 2 orders is to decrease that 330-foot heel-toe setback to 100 feet. Both of these requests are going to, we're going to put on evidence technical data today. I'm going to let everybody know it's going to be a thrilling technical presentation today because that's really what this is about. It is about the data used to understand whether or not we can shrink those setbacks without causing drainage and still protecting correlative rights in the surrounding drilling and spacing units, right? And so we believe that based on that evidence and technical data, that this relief sought will in fact protect correlative rights. It's going to prevent waste because we're going to recover more hydrocarbons. It will also help to minimize surface facilities and really allow maximum recovery of the resource. I can tell you just on the outset that these setbacks that we're asking for, I know when you're looking at 330 and 100, you're probably like, wow. On the other hand, setbacks from 50 to 100 feet are very common for horizontal wells in many other states in the nation. North Dakota, New Mexico, Texas, Ohio. Our land witness is going to discuss some of these areas a little bit more closely, the specific orders and things like that, but this is not a completely out of left field. Indeed, the entire state of New Mexico has statewide 100-foot heel-toe setbacks for all horizontal wells for all formations. So I just want to give the board some comfort that we're not coming up here, asking for something completely out of left field. This is something that's been proven through data and proven through drainage models as well, and we've got all those fun cartoons for you to look at today. I will note that the division has filed a technical memorandum in this case, and that memorandum, importantly, does not object to the increased density for the vertical wells. It basically says they've got kind of 4 points in there. And the division says, look, if you want to protect correlative rights of the owners and interests that adjoin these 1280s and these 2560s, these existing conservative 330-foot heel-toe setbacks should be maintained. And they really have 4 points, and I'm sure between the testimony today that'll come out, but the short version of that is, the first point is that the microseismic data that we had depicted in our exhibits was subjective interpretation. It didn't depict actual or raw microseismic, and there's an interpretive piece in there that you can kind of, one person can look at it and see one thing and another person can see another. And that the fracture half lengths that we depicted in our exhibits were unclear. The second item they brought up is that although the dimensions and extent of frac stimulation are key to figuring out drainage, they're not the only variable. If you want to arrive at a unique and accurate drainage area for a given well, it takes more than just your frac stim angles. The third issue is communication between reduced setback horizontal wells and non-reduced setback horizontal wells can create surface stresses that are going to result in a loss of resource on one or potentially both of those wells. And the last thing is that no evidence has been really presented requesting similar setback decreases for vertical wells. We've got responses to all of this. Following the receipt of the division's technical memorandum, folks from CH4 Finley worked with folks at the division, trying to understand their specific concerns. We filed amended exhibits. Thank you to the board for approving our request to allow those exhibits to be filed and to be used today. We tried to focus specifically on the items in that technical memorandum that the board or that the division had concerns with. So one other little housekeeping item before we get into that, before we get into our exhibits, is that I do have to note there is a typographical error in the caption in this matter. The name of my client is CH4 Energy-Finley, Utah, LLC. I don't think at this point it's a material problem or issue, and any subsequent order that is issued by the board when we do the proposed order process, if we get there, that it will bear the proper caption. And the second item is that in our request for agency action, it cites that CH4 Finley's state of organization is Texas and that they're based in Dallas. Their state of organization is Delaware, and they are based in Fort Worth. I'm going to ask both of those questions from a fact nature from my my land witness so we can get that into evidence. I don't think either one of these is a material issue. We just wanted to note the errors and fix it this way instead of filing a bunch of stuff that everybody's got to look at. So that being said, I'm going to turn to my first witness, and I'll ask Ms. Stoley to please introduce yourself by name and title.
Dieter Stoley, I'm Senior Layman with CH4 Energy, Findlay, Utah.
Okay, and have you ever testified before the Utah Board of Oil, Gas, and Mining before?
I have not.
Okay. Can you please provide just a basic description of your educational and experience background in petroleum land?
I have an undergraduate degree from the University of Colorado and a postgraduate degree from Southern Methodist University. Since 2006, I have worked in-house with oil and gas companies, almost exclusively with dealing with land matters.
I wanted to ask the board if they need any further qualifications.
Board members? Seeing none, no.
Okay, I was just making sure. So with that, we'll go to our first exhibit. I'm just going to skip here through our table of contents. This will be Exhibit L1. Ms. Stoley, can you please describe what's depicted on this locator map?
What's depicted, you see that red box, those are subject lands. You see they're located in northeast Utah. It's an area that we call our Rocky Point. You want to move on to?
Sure. I will move on to Exhibit L2, which is going to zoom in on that a little bit more.
Okay, as you can see, the subject lands located on 3 south, 1 west, but they are bifurcated by the county line between Duchesne and Uinta. See that they're about roughly 5 miles south of the city of Roosevelt. And the action today, it's only limited to those lands.
And orders 139, 134, and 139, 158 only cover the lands in this box, correct?
Yes, that's correct.
Okay. Moving on to Exhibit L3. If you could describe a little bit more about what is there right now in our proposed spacing area.
So in this area, there are only 2 orders that cover this. It's Order 139, 134, which is, he had previously stated, created 7 stand-up 1,280-acre drilling units. Within each individual 1,280-acre, there are 8 vertical, directional, or short horizontal wells. Those wells, for the vertical and directional, the east-west drilling unit boundary setbacks, currently 660 feet. The short horizontal wells have a 560-foot east-west drilling unit boundary setback, and then the 330 north-south setback for all the wells. There's also 17 long lateral horizontal wells with a 560-foot east-west drilling unit boundary setback, also having a 330 north-south. When you move on to Order 139, 158, it established 5 2,560 stand-up units, which authorized 3 stacked section line unit laterals. All of those contain a 330-foot north-south drilling setback. Today, what we're asking for is limited to the shortening of the north-south drilling unit setback and the increased number of density wells for verticals. I want to point out we are not asking for any changes to the east-west drilling setbacks, nor are we asking for an increase in the number of horizontals.
Okay. I'm going to go to the next slide, but before that, I'm going to ask you those 2 quick factual questions. Could you please state the full name of the applicant in this matter?
CH4 Energy, Findlay, Utah, LLC.
Correct. And their state of domestic incorporation is?
Delaware.
And their principal business office is located in?
Fort Worth, Texas.
Thank you. Exhibit L4, the notification area, what notice we gave and who we gave it to. If you could please describe what those boundaries are, the dotted lines, so that the board understands what they're looking at here.
Dotted line on both the north and southern borders, that's what we consider to be our 4th mile buffer area. Using our internal lane records and the county records, we did send notice to all working interest and unleased working interest owners in that area, along with the Ute Indian tribe.
Okay. And when you say notice, you mean you mailed copies of the request for agency action to all of the parties inside of the red outline here, as well as all of the parties inside of the dotted outline, correct?
Correct.
And those same parties would have received notice via publication from the board, correct?
Correct.
Okay. And in terms of, well, I have a note here to mention the memorandum, but I think we've done that already. So with that being the case, I think that gives a good understanding of who notice was provided to. Let's talk on Exhibit L5 of the current working interest ownership in the land and the breakdown of that ownership between fee, tribal, allotted, and state.
Yes. As you can see, for all of the current 1,280 acre DSUs, we are the majority working interest owner. When it comes to the mineral ownership, as you can see on the lower left-hand corner, it's roughly about 65 tribal owned, 3.1 state, about 30% fee.
Okay, and those are figures across all of the subject lands,
Yes.
correct? That's the average percentage across the lands.
Correct.
So any one of these individuals may have more or less than those numbers, correct?
Correct.
Okay. I'm going to go to Exhibit L6. We had said that we're asking for 100-foot setbacks. If you could please discuss with the board some of the other places in the country where similar setbacks to what we're requesting today are seen, what those states are, and what those setbacks are.
As you can see, first of all, New Mexico does have a statewide 100-foot setback. For all areas, state of Ohio has 150-foot heel-toe setbacks. See, from the extensive list on there, there are multiple counties and areas in the state of Texas covering various formations that have the reduced 100-foot heel-toe setbacks. And North Dakota and the Bakken actually does have a 50-foot.
Correct. And that will conclude our land testimony and exhibits, but I will ask if exhibits L1 through L5 were prepared by you or under your direction, supervision, and control?
They were.
And based upon your testimony in exhibits L1 through L6, do you believe that the relief sought in the RAA, specifically increased vertical directional density and 100-foot heel-toe horizontal setbacks, will protect correlative rights of parties both within and outside of the subject DSU?
I do believe so.
Okay. And do you believe this is also necessary to minimize waste and surface impacts and afford maximum resource recovery?
I do.
I have no further questions for Ms. Stoley.
Vision questions for this witness.
Ms. Stoley, thank you very much for your testimony today so far. You did comment a little bit about your previous work history, but do you have a lot of experience in the Uinta Basin?
I do not.
You do not. So you wouldn't know if there's any unique considerations as to the lands in Uinta Basin that would distinguish them from the lands in L6?
No, I would not. While my experience is in the lands in L6, I would have to defer to my coworkers as to the specifics as to the geology in those lands.
Okay, and I'm not trying to be too glib here, but are any of these exhibits or anything mentioned in L6, is that within the Uinta Basin?
No, it is not.
And so there's nothing specific to the Uinta Basin that's being presented here?
Not in L6.
Okay. And this might be shading into geology slightly, but are the formations that are being discussed in the exhibits here in L6 similar to the formations in your application lands?
That is going to best be answered by my coworkers, and I will defer to them on that.
Okay, so then I will withhold my questions on that front. I guess I would just state for the record right now, I'm not sure the relevance of L6 as pertaining to these subject lands in this case. Yeah, and are you familiar with who applied for these spacing requests in these exhibits, or what evidence was proffered in those?
In L6?
Correct.
I do not know that.
Okay. Is anybody prepared to testify about that
No.
today?
I can only testify that I have spent the past few years of my career exclusively developing lands via horizontal drilling with a 100-foot setback as seen in, say, the Leon County.
Okay. Thank you very much. No further questions for this exhibit at the moment.
Board members, any questions of this witness? Mr. Moon? Not hot.
How long has New Mexico had a 100-foot heel toe? That's their statewide default?
Yes.
Back. And how long have they had that, and what did they have before, and, you know?
I do not know, but I'm more than happy to prepare something to be filed later.
Yeah, it'd be interesting to see what their whole discussion was about that.
And Mr. Moon, maybe I can answer your question a little bit there. It's more about the similarities of the formations and how they are developed is the reason that these are here, and that relevance will be further developed through engineering and geology testimony.
No, I think it's good information.
Ohio's statewide too.
North Dakota, though, do they have a statewide? This is a particular ACE number. Is that their statewide statewide? It's not. It's just
Not to my knowledge.
What is their statewide default?
I don't believe they have a necessarily a statewide default, but I would say it's about 150 feet. If you took 15 random horizontal spacing orders and you looked at them, they would probably be all right at 150 feet, somewhere in there.
Okay.
So this was actually shown not because we want to go to 50 feet, but we showed there's people that have asked for and gotten less than that and proved that geology and testimony up. And so that's what the hope here is that we can show enough similarity at the formation level, because that's really what matters, right? I mean, that's what the setbacks are done on, is formation and development method, how you're going to, physically go in there and develop that well, what your angle is going to be for your azimuths, for your fracs. So that's why we introduced it in the land exhibits, and we will go back to it as necessary.
Ms. Davis.
On Exhibit L5, you've showed your working interest as anywhere from 90% to 100%. What is the ownership of the half mile that you notified on the east and west, north and south, of these lands? And did anybody object? In other words, you had, if you go to Exhibit L4, you show the notification on sections 9, 10, 11, 12, and sections 1, 2, and 3, and section 28.
Correct.
So you have a working interest inside the red box. Who owns the working interest in the half mile? Was it a half mile or a quarter mile?
We use a quarter mile buffer on the north and the south, not on the east and west, because obviously we're not changing those.
In the quarter mile buffer, do you have a working interest, or does someone else own that working interest? And what were their comments when you notified them?
Well, let's split that question. The comments when you notified them, we haven't heard back from anyone in specific other than Newfield Ovintiv, who says we're aware of your request for amendments. We don't have an issue. They didn't. So, I mean, you take that for what it is, but we have that. There was no issue. As far as anyone else, we haven't heard. There's been no protest filed. I haven't received any phone calls, and I'll let Ms. Stoley answer those same. Like, as the attorney for this matter, I haven't received those phone calls, and I'll ask her to answer if you've heard if you've been contacted by any other of the operator or the working interest owners in the buffer zone on the north and south.
We have not. No, there have been no protests, and we've not been contacted.
The second part of my question is, do you have a working interest in those buffer zones on the north and south?
We do not.
Okay. Other questions of the board? Seeing none, Mr. Chicken, please call your next
Real quick,
witness.
so is that, who does have that working interest?
Majority of working interest is Newfield Ovintiv.
Okay. Ovintiv, I need to start
Ovintiv,
saying
yes,
that.
sorry, I know.
Say it.
I've screwed it up twice already today, so
Ovintiv.
Ovintiv, yes.
There are some smaller ones. I can't give you the complete list at the moment, but they are by far the majority.
Okay.
Thank you. Call your next witness.
So because this is a fairly technical presentation from here on out, and I have spoken to Mr. Kessinger about this beforehand, what I'm going to do is I'm going to call both of my witnesses because they both have testimony that they need to offer. We have 20 exhibits here, and about 15 of them have testimony that's a mix of geology and engineering. And this also allows the board to have both witnesses on deck to answer questions as well. And so unless there's an objection, I'd like to put them both up at the same time to go through it.
Division?
No objections from the division. It was communicated to us prior.
Board members, any objections to proceeding that way? We appreciate it, so please proceed that way.
It might save time, too. We'll see. As stated earlier, our witnesses for geology and engineering are going to be Mr. Shea Atkins, who's on Skype, and Mr. Porter, who's sitting next to me. The first exhibit, I'm going to announce this is Exhibit G&E 1, and it covers existing wells, and I will ask Mr. Porter and or Mr. Atkins to please comment on what is depicted in this exhibit.
So what's depicted in this exhibit, the red outline is the application lands with the sections shown inside there. And there are 27 existing producing wells inside of the application lands. Of these 27 producing wells, 3 are vertical wells, 7 are short lateral horizontal wells depicted with the black arrows, and 17 of these are long lateral horizontal wells depicted with the brown arrows. And these are varying formations, horizontal benches in the Castle Peak, the Uteland Butte, and the Wasatch.
Okay. We'll move to Exhibit G&E 2. This one is a west-east cross-section within the subject lands. If you could please describe what is depicted on Exhibit G&E 2, please.
Yes, G&E 2 is a cross-section across the application lands and will also serve as type log for the rock across this lands. The green line going from west to east corresponds to the cross-section. The application interval is approximately 3,400 feet, consisting of the lower Green River and Wasatch formations. The Wasatch formation consists of approximately 1,200 feet in this area, with approximately 2,200 feet of lower Green River. And on the right side of the cross section, you can see a little bit leading into what we'll discuss later in the development model that CH4 Finley sees for these lands, with the deeper formations, the Castle Peak, the Uteland Butte, and the Wasatch being more continuous rock, carbonates, a mixture of carbonates, dolomitic carbonates, and shales, and silty and silt intervals. And we plan to develop those horizontally, with the shallower, more fluvial deltaic depositional environment in the Garden Gulch and the Douglas Creek, with a plan to develop that vertically.
Okay. Mr. Porter, do you have anything to add for this particular exhibit, G&E 2?
No, sir.
Okay, thank you.
Before you leave that, just to be
Yes, sir.
clarify, the black shale or the Castle Peak, you have on the right side horizontal development, vertical development. Will there be a distinction in which those two fall in?
Yes, we have a later cartoon that is all, you take one look and it explains what this is. The general idea is that the vertical wells are just not going to develop those deeper formations because they're better developed with a horizontal well model. But we do have a cartoon for you a little later that kind of shows you how that works with the well, with the increased vertical density and with the setbacks and everything.
Thank you.
Exhibit G&E 3, getting into some of the microseismic data that we've used to prepare this request. Mr. Atkins, if you could please describe what's depicted on that exhibit, please.
So depicted on this exhibit, inside the application lands are 3 wells located or identified with stars on the map where CH4 Finley has microseismic data in the 3 separate horizontal benches across this property. The graph across the top illustrates the fracture azimuth and half length of the 3 projects, with on the far right showing the averages of these 2 and what we decided to use carrying forward in further calculation. So as you can see, the fracture azimuth for the 3 projects of north 81 west, north 90 degrees west, and north 83 degrees west for an average of north 85 degrees west, which is a relatively flat perpendicular to the section line azimuth. And then a corresponding fracture half length of 199 feet, 343 feet, and 215 feet for an average of 252 feet. And so carrying forward for some of our calculations, and then we also show a doubling of these calculations, but the 252 feet half length and the north 85 degree west azimuth will be carried forward.
Okay, thank you. Mr. Porter, do you have anything to add to Exhibit G&E 3?
The one thing I guess I would add is just to give a little bit more information regarding these fracture azimuths. What drives the fracture azimuth are the present day stress fields. And so in this case, you've got a very dominant maximum stress field from north to south. And so that's why your hydraulic fractures will propagate east-west.
To help the board to make sure we're all clear, and for the record, what would be due north-south in terms of northwest? Would that be 0? North 0 west?
Yes.
Is that correct? And due east or west would be?
90 degrees west.
90 degrees. So we're talking about almost horizontal.
Yes, sir. Correct.
Fractures. Okay.
Which runs parallel to the
I stated another way, the fracture is, natural fracturing is, no, the
Hydraulically induced fracturing.
hydraulically induced fracturing is perpendicular to the wellbore, pretty close.
Yes.
Okay.
Yes.
Mr. Church.
On the table at the top where it talks about the projects, is it project 1, 2, and 3, do those relate to the individual 3 wells? So
yes,
project
sir,
number 2, which well is project number 2? Is it the furthest south?
No, sir. It's the one in the middle. So they're kind of set up in a working from left to right, 1, 2, 3.
Okay,
So 1,
the middle top one.
2,
Okay,
yes, sir, and 3.
thank you.
Proceed.
Moving into Exhibit G&E 4, more microseismic, drilling down a little bit more here on the actual microseismic data analysis. If you could please describe what's depicted there, Mr. Atkins.
So there's a lot going on here, so bear with me as we work through it. So what you're looking at is, so we took the data, the 3 wells, and we took a larger scope of data from one well, shown with the star on the left. And the reason we chose to drill down on that one is the quality of the data and the way that it was acquired. So what we're looking at on kind of on the right with all the dots and the arrow is the raw microseismic data. And the way this was this data was gathered was with the combination of a vertical listening well at the heel, as well as a horizontal listening well approximately 250 feet above the fractured well. So it's a unique situation to have more than one listening well. So they were able to triangulate the data and get a much more clear picture of the rock that's actually being stimulated. The typical way to do this is to have one vertical well as close proximity to your horizontal well as you can. In that case, you have a little bit of skewed data, but we have very good data quality here. So as you can see, based on the interpretation from ESG Solutions, they show a very flat orientation indicated by the arrows along the wellbore with all the scatter plot dots. Each of those represents a frac stage that was monitored through microseismic. And it also, you can see how they all stay within the stage cluster and don't deviate or show any toward or heelward growth. Everything stays very nice and compact inside of that stage. The rows diagrams that you're looking at, they also tie back to the previous data that was shown, and this is kind of the raw data of where those numbers came from and those averages came from. So the rosette plots, so the full fracture extent plot would be any and all events that were measured. You inevitably end up with a little bit of data that's outside of the core cluster. And so you can see that's even flatter. But when we do the connected on-zone fracture extent is where we get the 83 degrees. And so it's actually painting a more pessimistic picture, I guess you would say. If you use the full fracture extent, it's closer to flat. The image on the left shows the little cube diagram in the bottom left shows a stimulated reservoir volume for one stage. So you can see how tight all the microseismic events are staying to the wellbore and how they're all compact within that fracture stage with the east-west growth or the half length of approximately 215 feet and then a minimal upward growth of 163 feet. And the 163 feet upward growth will also be used later on in our volumetric calculations.
Okay, and Mr. Porter, did you have anything to add?
No, I don't.
Okay. We'll move to Exhibit G&E 5 and drill down even further into pre and post proppant addition and how that affects the microseismic. Mr. Atkins, if you could please discuss what's depicted on Exhibit G&E 5.
Right. So as you said, we'll just take the previous data from the same well and break it down even further. And keep in mind, this is real data from a real frac job with multiple angles to sense all this data. So the exhibit or A, letter A, wellbore shows the microseismic events that were detected during the pad portion of the frac job or prior to any proppant. So it was just fluid being pumped in that stage. And so really that extent is the full fracture extent. That's the maximum half length. And as you move from letter A over to letter B, when proppant is now introduced into the wellbore, you see all of your events are clustered around the wellbore itself, and you don't see additional growth. So all of your early growth is during the pad event, followed up by just adding near wellbore complexity with the proppant. And then the letter C is the post-pumping events. And so everything is still staying within those nice stages. You're not seeing any additional growth toward or heelward. And really you're just trying to stimulate the rock as much as possible near wellbore. And just to kind of add to that, Steeds for Finley has proprietary methods and things that we want to do going forward to actually enhance this near wellbore and limit any further growth. So we view these frac half lengths presented today as a maximum possibility.
Okay. Mr. Porter, do you have anything you would like to add to the testimony supporting Exhibit G&E 5?
No, I don't.
Okay. Okay, Exhibit G&E 6. Mr. Atkins, if you could please describe what we're looking at there in terms of what are these core data wells? We can see where a core data well is, but the other wells that are listed here, and distinguish them by formation.
Right. So the map on the top left, the stars indicate 2 wells with core data through the horizontal target intervals. The primary horizontal target intervals being the Castle Peak, the Uteland Butte, and the Wasatch. One is in and one is immediately offset to the application lands. And so the purpose, then this will kind of bring together the microseismic with the rock. And the way that we view things is that due to the nature of the rock, the only rock that we're effectively draining or draining at all is the rock that we stimulate with our frac job, the stimulated reservoir volume. And the reason for that, if you look at the table in the permeability column on the far right, is how low the permeabilities are of this rock. There's porosity, there's storage space, but those pores are not connected in a way that the fluid can flow in the life of a well. It's more of a geologic flow kind of measure without being stimulated through the frac job. And so that kind of brings it all together in that it's CH4 Finley's view that the only rock that's being produced is the rock that we touch with our stimulation job.
Okay. And Mr. Porter, do you have anything to add to Exhibit G&E 6 with respect to either of those, either the in the subject lands core data well or the core data well that's lying just outside of the subject lands?
I think one of the things I would point out that these permeabilities and the existence of horizontal wells today, they exist because with the new fracture stimulation, we're able to open up and produce commercial wells in much tighter formations. And so this is very much in line with why this project, why we're tackling the Castle Peak, Uteland Butte, and Wasatch from a horizontal standpoint. These low permeabilities are really cost prohibitive from a vertical development standpoint. However, with horizontal drilling, we can effectively deplete and drain the reservoir and therefore generate more commercial wells, more revenues for the state, for the tribe, the mineral owners, and for us.
Okay. Thank you. We'll move through to Exhibit G&E 7, where we're going to be talking about the current spacing, and if you can please show what's depicted there, or describe what's depicted there, sorry.
So what's depicted here is an illustration of the fracture orientation based on the microseismic data, along with the half length that we previously discussed. So 85 degrees and the 252-foot fracture half length. And given the how flat, the flat nature of that orientation, and the fact that it's our belief that we don't believe that we're producing anything that's not touched with our stimulation job, there's effectively 308 feet of undercovered hydrocarbon at the heel and toe of every horizontal well that would be drilled.
Okay. Mr. Porter, do you have anything to add to this?
No.
Okay. That's because it's kind of an interim exhibit of sorts. Exhibit G&E 8, continuing on with that same line of thought along the microseismic, looking specifically at the toe interval, where the bottom of the well, if you will. If you could please describe what's depicted.
Right. So this is a continuation of the previous slide that's corrected to show a 100-foot setback and how that would be, where that would be in relation to the lease line and how that would affect the mineral owners. And so the offset. So previously said, we don't believe that we're producing anything not stimulated with a hydraulic frac job. And so given the 100-foot setback and the orientation of the fracture angle, there would still be a 78-foot buffer to enable to protect correlative rights from offset owners, while also allowing us to recover the additional 230 feet of hydrocarbons that would be left behind as it currently sits.
Mr. Porter, do you have anything to add to Exhibit Genie 8?
The only thing I'll add is there are some additional slides coming up that will actually address this in more detail.
And I think it's important to note here, maybe, I think Mr. Atkins may have mentioned it, but I want to also just ask him this specifically. Under the current spacing, under Order 139, 134, are there any interwell setbacks between vertical, directional, and short lateral horizontal wells?
No, sir, they're not.
Okay. I don't know if the board knew that, but that's an important thing to understand here is you already have only setbacks under 139, 134 between the big 2-mile lateral horizontals and the other types of wells. Those first 3 categories of wells have no interwell setbacks. You can get as close as you want to one another, and there's no reason you can't. We'll move on to Exhibit G&E 9, continuing to look at this tow interval. And if you can please just describe compare it to the G&E 8 and the doubling.
All right, so the only difference for this is just taking into account if someone were to say there are some interpretive natures of microseismic and just to be on a cautionary view, we in this slide we double the fracture half length. So if there were some sort of change in the stimulation job that would double that length, we wanted to depict that even with a doubling of the fracture half length that we've seen in multiple wells, there would still be sufficient protection from correlative rights of the offset owner, showing a 56-foot setback remaining at that time.
So is it accurate to say that even if you have a frac that's twice as big as you thought it was going to be, this is what it would result in?
Correct.
Okay. Mr. Porter, do you have anything to add for Exhibit Genie 9?
No, I don't.
Okay, thank you. We'll move to G&E 10, original oil in place. If you could please describe what is depicted on this exhibit.
So depicted on G&E 10 is a process log that CH4 Finley had calculated by a third party, Newtek Industries, in order to look at to help us calculate oil in place in the formations on the application lands. And so what you're looking at is a combination of open hole electronic logs as well as core data in order for them to put together a model that calculates the original oil in place on these lands. And so the combination of gamma ray, resistivity, porosity, TOC, total organic carbon, the different mineralogy, so the limestone, the dolomite, the sand and the clay content, water saturation, oil saturation, permeability, all goes into the calculation for oil in place. And so what you see on the top right is Newtek's calculation for this well that's inside the application lands for the various horizontal benches, the Castle Peak, the Lower Castle Peak, the Uteland Butte, and the Wasatch. And so we utilize this to have a third party kind of checks and balances on our own calculations, and also going forward, we'll apply these numbers going forward into our volumetrics and drainage area and things of that nature.
Okay. Mr. Porter, do you have anything you'd like to add to Exhibit G&E 10?
The only thing I would add here is we've got our own in-house petrophysical model, and we wanted Newtek to be able to do the analysis and compare if we were in the same ballpark, and indeed we were. Had very similar results.
Okay, so in other words, you've come up to you and the third party both arrived at similar results.
That's true.
And is it true that as we go back through some of these exhibits, and I'm just going to so the board can see, When we talk about Exhibit 6, we have Core Lab on there. ESG is on Exhibit E4 and E5. These are all third parties these are the third parties doing the actual analysis, correct?
That is correct.
Okay, so it's not your analysis necessarily, it's them doing that analysis and being able to tell you what they found. Okay, Exhibit G and E11, and I'll let the board know, you're going to see 11 and 12 and 13 and 14 are very much like 8 and 9 were. We're going to show you the base, and then we'll show you the doubling. If you could please describe on Exhibit G and E11 to the board what this depicts in terms of the map view for drainage.
What this shows, it depicts in just a map view, a plane describing what we view the drainage area from a horizontal well is. I won't go into a lot of the detail on the left-hand side. It's just laying out the knowns for the calculations, but setting up from the first perforation in the wellbore to the last perforation in the wellbore, we're viewing everything between those 2 points as being stimulated. One of the things that the evolution of fracturing horizontal wells has been reducing stage lengths and more clusters. And what that shows is that in the early days of horizontal completions, we might have only been putting three clusters of perforations within each stage. And so you ultimately have a lot of hydrocarbon immediately adjacent to the wellbore that is never produced. So in just looking at this rectangle, this is the volume related to, like I said, from toe to heel. And then what we did is we took what I think is a worst case scenario and said that we will get 75-foot extension in the shape of an ellipse on either side of that rectangle. And that's shown in the pink color. And what we see ultimately...
Sorry, I'm just going to use the pointer here to show the board. This is the kind of cap that he's showing when you're seeing this is the well in between and this is the outer edges of the frac.
So taking all these, and then given that the formation thickness, which we think is adequately bounded for fracture stimulation, is 163 feet, and then we took this rectangle and ultimately one ellipse, calculated the volume contained therein, utilizing the NewTek oil in place numbers, we arrived at 6.7 million barrels of oil in place. Our assumption is at this point in time, we anticipate an EUR of 800 MBO, which would generate a 12.5% recovery factor.
Okay.
Question, please, Mr.
So with that 12% recovery factor, does that vary between or amongst those four formations at all? Are you using this as a generic recovery factor for all of that oil in place?
No, I'm actually using it specifically for the Uteland Butte.
The Uteland Butte?
Yes.
Do you see a wide variance of recovery factors among those four formations? Is it related to the permeability that you would see on the electric logs, or is there that much variance?
Primarily, it's not going to be permeability that drives that. The original oil in place based on saturations will drive the oil in place, and then ultimately the recovery. On the previous exhibit, G&E 10, you actually show the calculated oil in place for the Castle Peak, the Lower Castle Peak, Uteland Butte, and Wasatch.
So you feel the recovery factors directly related to oil in place and not to other factors?
I would say that effectiveness of the stimulation, the amount of stimulation, how densely you fracture the rock is going to be the big driving factor. Because as we stated earlier, the rock permeability itself isn't very good. So we've got to crack the rock. And so ultimately what we hope and intend to do with our fracture stimulation design is that we will do our best to create fractures, hydraulic fractures through all this rock. And one of the things that will happen in high density stimulations, our objective, we don't want to frack long links, because what happens is long links, you may create events that are out 1,000 feet away from the wellbore, but ultimately you're not getting proppant anywhere close to that. And so you end up having energy that you expended on the horizontal, on the fracking, that effectively is not productive.
Thank you.
Follow-up question to that. Oh, Mr. Borden first.
Forgive me, I'm a hard rock geologist, so I just need you to explain a term to me. The fracture half length, is that the median length of the fractures that are induced? Is it the average of all the fractures that are induced? Could you just explain to me what that term is describing?
Shay, you want to?
Yeah, the fracture half length is the maximum direction in one direction. So the full fracture width on one side of the wellbore would be 250 feet, and again another 250 feet in the opposite direction on the other side of the wellbore.
Okay, that's very helpful. Thanks.
And so I was going to say, when you double
But
those.
the second half of his question, is it a median or is it an average? Because obviously, is it the maximum, the medium, or the average? Because when you go back to exhibit G and E5, I mean, clearly there are different sizes of fracture half lengths.
Right, it's going to be, so there's, you see a few of the data points that are on G&E 4, I guess.
It's three.
A few data points that are.
Five.
Sorry.
G&E 5.
5? Okay, it's going to be,
Four
it's going
has
to be
the
that
same
maximum length. The maximum length in one direction.
So
So you can see it's a very conservative number on some stages. Some stages have a maximum length, and then other stages it's very minimal.
So it looks like the green dots are the furthest from the wellbore. So those are 252 feet out. Is that what you're telling me? The green dots?
Yes, ma'am. Yes, ma'am, based on the interpretation by ESG.
Thank you.
And then my question has to do with again with the half length. Is there any portion of that analysis or determination of what a half length is as also how far the proppant gets out, or is that just the fracturing?
So I think that part of the message for that G&E 5 was to show that the fracture half length is going to be the maximum distance from the wellbore, and in general, your fracture half length is generated in the pad portion of the stimulation, whereas your proppant portion of the stimulation is going to be focused near the wellbore, because you're not going to be able to carry that proppant all the way out to the furthest fracture that was created.
Okay. Then my next question is just a general question, and that is, we're seeing a lot of almost a preponderance of 10% recovery factors. Can you tell us a little bit why you think you're experiencing a 12.05% recovery factor, and is it because it's overpressured? What is determining that from what everybody else is seeing?
Well, I think go ahead, Shay.
I was going to say, I think there is a little bit of variation in pressure, but I think the difference between 10% and 2% can be a slight variation in your oil in place numbers, depending on the lands. Depending on, I don't know where exactly your 10% is coming from, but there can be a 2% change depending on how much oil is already in place and the quality of the stimulation on those lands.
And the one thing I would add to that is I wasn't as much concerned by the absolute number as much as I was that it conformed to what I consider to be a normal maximum standard being 15% for primary recovery.
Okay. And then, did I see on one of your exhibits that you had original oil in place per section? Or is that per 1280 on the exhibit 11?
That is per section. That is per 640 acres.
It's a lot of oil.
Yes, sir.
Okay. Thank you for letting us intervene. Continue, or one more question, Mr. Moon.
So looking at Exhibit G&E 9, so this shows your fracturing basically following the natural fractures. Wouldn't you have some fracturing taking place north and south, from the wellbore? Is that because you only perforate east and west, or my question is, wouldn't you have some going directly south here?
So I did want to point out 9 is the doubled up super safe one. Did you want to refer to 9 or to 8?
Either one.
Okay.
Either one. Just
I think the creation of fractures to the north of the toe, or to the south of the toe, I think you're going to get minimum growth in that direction, because one of the things we see from dipole sonic and what we see from the microseismic is we see these very long ellipses with aspect ratios greater than 4:1. And so that's why when I describe 75 feet of growth, that's half of a stage length. And if we actually were overlapping that much, we wouldn't see incremental gains on 150-foot stages. So we really feel like we're getting minimal growth north and south.
And just a practical question, when you perforate, do you purposely perforate out the direction of the natural fracture, or do you just perforate wherever and it naturally goes with the natural fracture?
So I'd like to let me answer that real quick. So the thing with the microseismic, the reason that the fractures grow in that direction is that's the minimum stress direction. It's all about stress orientation, and so that proppant and that fluid is not going to go towards the maximum stress. It's only going to take the path of least resistance. And so that's the reason that we drill our wells north and south, is so that is perpendicular to that path of least resistance, which is 85 degrees to our wellbore. And so that's the whole purpose of doing that, because if you did it the other way, then your entire frac job would run parallel to your wellbore and you would have no outward growth. And so then your stimulation area, your stimulated reservoir volume would be just very minimal right near the wellbore. So that's kind of the reason for drilling our wells north and south. And as you move over to the western side of the basin, that stress orientation has shifted, and it makes sense to drill those wells east and west in order to be perpendicular to that stress orientation. And we have that data that we could show, but we felt like it was more representative to show data from an actual frac job instead of theoretical data that says what we think it's going to do.
And just one last question. So there's really no way to, after the fact, go back and produce this stranded resource, because on the east and west side you can add you
got 660 feet. You can put them this, but then you're running against the stress, and so you're not taking advantage of natural fractures east-west in this area.
Right.
Final question for me, if that's okay. You want one more question? Go ahead.
So just for my information, on your modeling with your microseismograms, can you model fracture height, or are you modeling the fracture height with these stimulations that you're doing?
We're actually
yes, sir. We mentioned fracture height, and that's, if you go back to on GNE 4, kind of where I described the the prime layout with having so the well that you're seeing is a Wasatch horizontal well. There is a Uteland Butte horizontal well immediately 250 feet above in it, as well as a vertical well at the heel. And so you're getting a very good picture of that upward growth, which we see is 163 feet, sorry. And that 163 feet upward growth goes into Mr. Porter's volumetric calculations that we were just looking at as well.
Thank you for quantifying that for me.
Okay, go back to Exhibit 9, please.
Sure. And I did want to ask Mr. Atkins, and again, this is because this is an actual frac stimulated horizontal well with another well stacked on top of it that could listen and can tell, like you could tell if the frac had invaded that other well because you would be getting that out of that other well. Correct?
That's correct. And these are all typical calculations that are done, but this is a unique situation to have a horizontal well listening on top of a deeper horizontal well. So it's very good data in the world of microseismic.
So go to Exhibit 9.
Yes, sir.
Just so that we're all on the same page. On that orientation, what is, when you're referring to heel and toe, which one is which? Oh, on that frac that's shown on that, one is 56 feet and one is in excess of 100 feet. Is the 56-foot one the heel?
So the 56 feet is, if we project that ellipse, that stage out 504 feet at an angle of 85 degrees, then you would get 44 feet towards the heel, closer to the lease line. So the 56 feet is the buffer zone from the adjacent lease line.
But it's the buffer zone to the heel, what you call the heel?
This is the toe interval of a well. Yes, sir. This is the toe interval, an illustration of the toe interval. And you would have the same orientation at the heel.
So the heel would be the same north-south or north 85 west, but the bottom one is the heel and the top one is the toe.
So maybe I can clarify.
Just make sure everybody's on the same
when you have a
definition.
horizontal well and it goes like this, right? Right where you start frac stimulating after the
I'm
curve,
sorry.
That's the heel, and the other side's the toe. So we're just looking.
We're not.
At the end
That's
of
not.
This is just the end of the well.
I
drew him a picture.
He drew me a picture.
I'm sorry. We're the ones who's supposed to be providing the cartoons.
And
so.
the big hand is on what, and the little hand is where? Thank you. I understand it now. Thank you.
Okay, I'm going to move on to, so now what we're going to do is we're going to go to the companion slide to 11, which is the ellipse view of the volumetrics. If you could please describe what's depicted on Exhibit G&E 12, please.
What I'm trying to show here is I'm focusing in on either the toe stage or the heel stage and showing what that rotation at north 85 west and as Mr. Atkins was saying, what the setbacks would look like and what that extent and what that illustration on GE 9 fails to show is the true shape of the ellipse. So actually the ellipse itself moves further towards the boundary. But that being said, if we look at this and on the chart on the left-hand side shows that the closest it gets to the boundary is 77.87 feet, so it's 23 feet away from the boundary. And mind you, this 75-foot, I think, is an extreme case. I think at most we're going to see a few feet, less than 10.
And so once again, even though this is the actual versus the doubling we're about to show, but even the actual has some safety built into it as well, correct?
Yes.
Okay. Mr. Atkins, do you have anything to add on Exhibit G&E 12?
I do not.
Okay. I'm going to move it to G&E, Exhibit G&E 13. If you could just depict what's on here in terms of the the doubling of all of the footages.
Right. Essentially what I've done is use the same setup, and instead of the 252 feet, I'm using 504 feet for a fracture half length. So you've got a little over 1,000 feet from fracture extreme on the east side to the west side. And again, using the 75 feet growth on the ellipse towards the, beyond the toe and heel. On this, given the same scenario, you cover much more acreage. You're up to 13.2 million barrels in place. At the 800,000 barrels, you're at a 6.02% recovery.
Okay. Mr. Atkins, do you have anything to add on this slide?
I do not.
Okay. We'll move to Exhibit G&E 14, and if you can please tie that into the map view of the volumetrics.
Certainly. This is taking it as indicated. It's kind of what we view an extreme case. We've doubled the fracture half lengths, and we're at 504 feet. And so at that point of the ellipse, we would be at 44 feet closer to the boundary. And then if you look on the left-hand side under the Y prime, you're showing that the closest you actually get is you move from the 100-foot setback, you move 86.9 feet closer to the boundary. So what I'm trying to show here is a very extreme case, and we still don't get there.
Question?
So again, just for our picture, if you were to be granted these offsets, the vertical component of the horizontal well that forms the heel would be steeper, right? Is that correct? You would would you re-enter the well and drill it steeper so that the heel would be closer to where the well is spudded, or how would you actually recover that?
Typically, we would already be at depth and coming in flat to the formation dip.
Okay, so that transition from near vertical to horizontal is so long, you just perf it back closer.
I think what he's saying is, surface location outside of the DSU, and you do your turn, and you're coming in at target formation. Yeah.
Okay, got it.
Right.
So-
we would plan the well so
So
that
the
we're
bend-
already horizontal at that 100-foot.
Right.
Interval.
So the bend is not in the DSU. The bend is not in that 100-foot piece. The bend is somewhere on the adjoining lands, and you're already doing, because that turn takes anywhere, around a half mile to go from vertical to horizontal. So there's not enough room to do it in there. You have to have that outside DSU self-certify that you've got surface use agreements, and then drill in.
Got it, I understand, thank you.
So stated another way, your first perforation is not less than 100 feet under your proposal. Is that
Correct.
not correct?
That's correct.
Hey, Mr. Moon.
So, yeah, that brings up a concern I was thinking of a while ago. How does this affect your drilling units above and below? So, say the drilling unit above, is that going to affect how close you can come? Because you've got that wellbore coming down and curving, and you're going to be perforating, 100 feet within the drilling unit. So, say you've got the one coming from the north drilling unit coming in. Assuming you're in the same structure, is there going to be some interplay there? Is there going to be some disadvantage to the neighboring drilling unit by having this setback so close?
Are you speaking from a drilling standpoint or a producing standpoint?
Both.
So from a
Drilling
drilling
and-
standpoint, it's kind of leading back to the slide that Ms. Stoley presented on. It's commonplace in other basins for 100-foot setbacks. And so from a drilling standpoint, it's very common to plan these wells accordingly, to locate your surface location and to plan the directional plan in order to be landed and going horizontal and at the 100-foot boundary to allow you to have your first perforation no closer than 100 feet. And from a producing standpoint, it kind of gets back to our whole presentation that we don't see that we're going to have any producing interference beyond that 100-foot interval. So we don't see a problem with drilling and completing and producing at 100 feet in the adjacent lands. And we plan to do so on the interior of the application lands of Rocky Point.
100 feet. This one kind of pulling up underneath us, but this none of this.
Ms. Davis.
None of
This
that's.
would actually be on this side of the boundary, right?
Yes.
You've presented a compelling case that you are going to increase well production from the lands that we're discussing, which is something that, of course, we're all for here in this room. So the only downside to allowing this is we're setting a precedent to allow you to get within 100 feet of neighboring lands which you do not own a plurality of the working interest. So my question to you is, if you were in those adjacent lands, do you object to this proposal? Because we are setting a precedent here today if we agree to this. So Brent, if you come back next time and say, I'm working for somebody else and we object, I want to know about it now.
So I wish I wish I could draw a picture of this so you could understand the way I kind of see it in my non-geologist engineer head, and that's if you've got the line, the section line, it's almost like, and I'll ask my witnesses to correct me, but because of the rock permeability, like they said, it's porous rock. There's holes in it, but the holes don't connect. So you can't really get through there without fracking into it. So if we know the frack extent, then we know that we're not going to crack those rocks. And because it's so common practice now that you're drilling into your DSU, right? Almost nobody puts their surface location on their DSU unless they don't have a choice. They can't get surface use agreements, subsurface easements, those kind of things. And so, but because of the way you're doing that turn, it's almost like if you're drilling this, you got two 1280s on top of each other, you're drilling the southern one, the northern one is coming in underneath the bend of the southern one. Does that make sense?
We're gonna give you a whiteboard.
So I'm telling you, I might need one. The point is that whether I think what you're going to see is just the opposite of that. I think you're going to see people that, to the extent they can do it operationally, they'll go in and re-drill that extra footage on the end of the toe and complete right up to it, and where they are stopping that completion is basically right underneath the curve of the well to the south. And because you don't have any perforations in that curve and the rock is very impermeable, you end up with a nice situation where you can squeeze those two in a little bit closer, get more of that resource. And as pointed out, as Mr. Moon's question was earlier, there's no other way to get this. You can't, there's not enough room to put a horizontal, another well in there, verticals or anything. There's no other way to get this waste right now. And if you've got rocks that are not going to talk to each other unless you force them to, you've got good protection against that communication. And again, this is on my, I'm not an engineer, but when it's explained to me in that way, and I can tell you this isn't parroted from either one of these gentlemen. This is what I understand from what they have, what they're presenting. So, yeah, I mean, I don't believe that I'm going to be in here, protesting, 100-foot setback anytime soon, because it is waste. It's very similar to the section line wells. You've got that space in between those setbacks going up into the governmental section line, and you're not going to recover it any other way other than putting a section line well in there, or, ironically, decreasing the east-west setbacks to allow you to stick another well in each of those 1280s to capture that waste. And the problem with this one, though, is the orientation's different. If you're drilling north-south wells, that's the way you have to drill them for the least amount of stress. And so you're not going to pick this up by drilling a horizontal across the bottom in between the two 1280s, because the frac job's not going to work, or it's not going to work as effectively.
So let me ask Mr.
We're going to
Porter.
hold you to that, Mr. Chicken. Just want you to know.
Duly noted, Ms. Davis.
Can I interrupt for a quick? Mr. Chicken, does your expert witnesses concur with your testimony?
Gentlemen.
Yes.
Yes, I do.
All right, we're going to, here's the plan, just so you know. We're going
Excuse me. So I want to clarify that you'd asked earlier if we own a working interest leasehold in that quarter of mile. While we do not, if you expand that quarter mile to half mile, go up to an entire section, if wells are drilled in the future under this type of spacing, I would anticipate that we would have a working interest in there and we would not object.
Just for the procedure.
that's very
we're gonna
helpful,
We're going to
Deirdre.
continue, and don't let me interrupt you. I want you to ask your question. I was just going to say, once these questions are asked and answered, we're going to take a break.
Okay.
So Susan, I'm sorry to interrupt you. Have you got an additional question?
No, Deirdre answered it. So
Okay.
thank you, Deirdre.
Let's go to Mr. Borden and then back to Mr. Church.
I have two questions. Number one, we've been talking about the maximum fracture half length here, which is inherently conservative, I guess. But looking at your microseismic plots, it looks like the fractures aren't distributed evenly between the borehole and the maximum distance. They're clustered right next to the borehole. If you were to pick the 90th percentile or 95th percentile of fracture half lengths around that borehole, are they a lot shorter than the maximum? Are they 95% of the maximum? Do you see what I'm trying to get to?
I think they're shorter than the maximum for sure. And I think as a completion practice, we see a benefit in not having large, long frac half lengths, because inevitably what happens is if a lot of your energy goes further away, then you have less energy near that wellbore. And we want to stimulate and bust up and prop and produce as much of that rock that's near the wellbore as possible. So like I mentioned earlier, we have some practices and techniques that we do to actually minimize that fracture half length. And a lot of the new frac methods going on right now are leaning in that direction also. So again, I think that the 252 feet is going to be a maximum distance.
Ms. Davis, you had a follow-up, or Mr. Borden, a follow-up?
Just a second question. I guess I'll follow up with something Susan had asked. If one reason you're able to do this, I assume, is because you have an optimum orientation, north 85 west. If it was north 50 west, you obviously would have a lot less room to play with in the toe and heel. Is that correct?
That is correct.
I have a macroeconomic question. As I go to the conferences and talk to different people about the Uinta Basin, it seems that there really isn't a consensus. There's still a lot of science to be done on fracturing and how to fracture it. I remember Newfield had a VP present, and he just said, we're still trying to figure this out. Is that still, on an industry level, still, you're still trying to figure this out a little bit?
I would say that the practice is evolving. It's trying to become more efficient and get higher recoveries and reducing costs. So ultimately, we want to produce maximum reserves with minimum cost. We're finding the application of certain stimulation fluids add cost, actually hurt us as far as reserves. Like I mentioned, the frac clusters, the stage lengths have all been evolving. So it's not settled at this point in time, I would say. This is the case.
Yeah, you're just confirming what I'm hearing is that while this is your best empirical information, there's still tweaking that needs to be done probably throughout the life of the field. You're still going to be looking at it and asking how you can do it better.
Absolutely.
Mr. Church.
I just wanted to ask Mr. Porter, what would your probabilities be with the competitor drilling to the south and the toe of their well now is going to be 200 feet from the heel of your well? And what is the probability of them when they frack that you're going to see well interference?
Based on what we've seen with the microseismic and the dipole sonic, that essentially, I don't believe that we will see
You
interference.
see zero probability of interference between those two wells?
Yeah.
Between their toe and your heel?
Yes.
And I would note that it's actually, if you take 100-foot setback in the one and the standard horizontal that has been used in the pilot orders, it's actually 430 feet away, right? Because their heel starts fracking and starts stimulating it 100 feet in, and the other toe has to stop 330 feet away, so it's 430 feet.
I'm saying if this is granted, though, if
If it is granted, that would be
That'd be
100 foot
100
into ours and 330 feet into
They
theirs.
would need an exception,
Yeah,
or to do exactly
yes, they
what they're
would need an
doing.
exception.
correct.
Absolutely, yes.
All right,
If we-
seeing no
just to
more
add to that,
questions.
Plan,
Any more you want to say about this before we take a break?
1 second, Mr.
I was
Atkins,
just
you had a
gonna say-
question?
Yes, sir. I was just going to add to what you were just saying that we, as far as the offsets, if we thought it was a problem, we wouldn't be wanting to do it internally on our own lands as well. We feel like that's the best way to develop the resource. And if we had interference in communication, then it would hurt the economics of those additional wells that we were to drill. And so when we drill a new well, we're deploying a lot of capital and a lot of dollars into the ground, and we want to see cost-effective results on every single well. So if we thought there was any risk for interfering those wells, we wouldn't take that risk.
So you're telling us all of the horizontal wells drilled to this point in the basin we have a lot of wasted resource?
That would
Very
be
well
my
could,
belief.
yeah.
Yeah.
Okay, we're going to take a break.
It's part-
tell you right now is the board is.
I've got all various members, including the president, everything sitting in screenshots. Shay just asked if we can see the
question on maximum, or is that the average to maximum, or is that the average to average?
No, that's great visuals.
That's my point. They're just getting too tight.
How are you today, Michael?
I'm doing well, Bart. How are you? Good.
Yeah, so he's just out of the office for a while, so they turned it on. So they did do it.
Okay, because I have to step out.
We're waiting on the thumbs up on the remote testimony. We got him there? Good. Mr. Atkins, can you hear us?
Yes, sir. Can you hear me?
Okay, we're good. Court reporter? Good. Okay. We are back on the record. Mr. Chicken, you're examining your geology and engineering witnesses.
Thank you very much, Mr. Chairman. I'm going to go to Exhibit G&E 15, which is going to show some of the project economics. So we'll tie some economics into our science here. Let's give Mr. Atkins here a second to get on board.
You with us, Mr. Atkins?
I'm here.
Okay, great.
Can you see Exhibit 15, Mr. Atkins?
Yes, sir. I see Exhibit 15.
Okay. Could you and/or Mr. Porter please discuss what is what's described on that exhibit in terms of the additional economic benefits of the request?
Yeah, so the project economics of Exhibit 15 really walks through the additional value of this incremental 460 feet should these reduced heel-toe setbacks be approved. So for a long lateral horizontal well, a 10,000 foot or 2 mile horizontal well would be an additional 460 feet of completed reservoir. Based on our estimates, that would be an additional 36,800 additional barrels of oil per well. This slide was put together a couple of weeks ago, but using a $55 per barrel of oil price for those 36,800 barrels, that would be the equivalent of just over $2 million worth of additional revenue per well. And based on a roughly $311,000 cost to drill those extra 460 feet would be a 6.5 to 1 ROI for that project. That would equate to an additional $91,000 per well of severance taxes, and over the remaining 102 additional long lateral wells left at Rocky Point, that would be an additional $9.2 million of additional severance tax collected by the state of Utah.
Okay. Mr. Porter, do you have anything you want to add?
No, sir.
Okay. Let's move on to our development model, and I think this is where I was talking. It gives a very good picture of how you do this shallow vertical, deep horizontal wells. So this is Exhibit G&E 16. If you could please describe what's depicted there.
So this exhibit is really a culmination of the full development model that CH4 Finley plans to execute and how we view the Rocky Point area. It's our opinion that an exclusive horizontal or an exclusive vertical drilling program would leave unrecoverable reserves, that you'd be leaving a lot of oil in the ground. So we see the best way to exploit these resources is a combination with shallow vertical wells, drilled and completed down to the top of the Castle Peak, along with the Castle Peak, the Uteland Butte, and the Wasatch being drilled horizontally. Something else to note is on the vertical wells. We're making plans. We've already executed in other areas, vertical drilling, where we use multi-well pads. So we have up to 4 or 5 wells per pad everywhere possible, and that just increases efficiency in all aspects from a drilling and completion standpoint to a field production operations standpoint, minimizes surface disturbance, minimizes surveys for arc and paleo and cactus and all the things that we need to take care of. It just minimizes and leaves as little disruption on the landscape while also maximizing the recovery of the resource below. We've done this in other areas, including Rocky Point. We have 2 test wells in Rocky Point. And so we feel like this is the model that's best suited to go forward on these lands.
Mr. Porter, do you have anything to add?
No, I don't.
Okay. Moving on to Exhibit G&E 17. These are going to be some of our Green River geometries, subsurface geometries. But if you can please describe what we're trying to get to with Exhibit 17, please.
So what you're looking at with Exhibit 17 is a LiDAR scan image of an outcrop down in 9 Mile Canyon of the Lower Green River interval. A LiDAR image is a digital scan of the outcrop, and then you can take that and map out these reservoir geometries and make interpretation based on their depositional environment. So what you're looking at is kind of a combination of channel and shoreline related reservoirs of varying heights and widths. But the main message here is that if we move forward with drilling on an 80-acre drill pattern, is what currently exists in Rocky Point, as you can see in the bottom portion, on 80-acre spacing, there's going to be sands and reservoir that's not intercepted by a vertical well at that distance. So all the wells, or all the sands and reservoir that are intercepted with a well are green, and then the yellow and orange are the ones that are not intercepted with a vertical well.
We've called that in the past 6 or 8 or 10 years as potato chips in a bowl.
Yes, sir, that's it.
Okay. Mr. Porter, did you have anything to add to this?
No.
Okay. So let's move on to G&E 18. So this is your 2 wells per 80 geometry, and this would be the if the request is granted today. If you could please describe the additional recovery you're going to see.
Right. So it's a little bit self-explanatory, but I'll walk you through it. Effectively, by adding the additional well per 80 acres, so effectively 40-acre spacing, you're going to intercept a majority of the sand body reservoirs in this interval and minimize waste. We feel like this is the way this is the optimal way to produce these lands in order to not leave behind waste. And it also leads back to the efficiencies to go ahead and drill these wells on 40-acre spacing from the get-go. To maximize efficiency on drilling, completions, and production, instead of drilling it all up on 80-acre spacing and then coming back to do that on 40-acre spacing.
Okay. Mr. Porter, do you have anything to add?
No.
Okay, and we'll get into our last two exhibits here. And this is these last two are very similar. They're going to show you the differences between the 80-acre and the 40-acre densities. So if you could please discuss what's depicted on Exhibit G&E 19, please.
Right. So on this exhibit, and we can move through these through this one fairly quickly, but what you're looking at, the application lands, the green circles are 3 producing wells. Vertical producing wells on the lands. We actually have other open hole logs from other wells, so we have a little bit more data to map from than what we're showing just based on the existing horizontal wells there. But currently there are 3 producing vertical wells, and so if we were to drill this on 1 well per 80 acre, there'd be 109 additional wells to drill on these lands. And so as we make our plans going forward for pad location and well siting, we're taking all this into account to make sure that we are choosing the optimal locations. So as we go to the next slide.
Which is G&E 20?
Right. So this slide depicts what it would look like drilled on 40 acre or 2 wells per 80 acre development. There'd be an additional 221 wells. And also just keep in mind that just because we're increasing the well count does not mean that we're increasing the pad count. It would actually be very, very similar to the same, depending on reach and things like that. But it would be very similar surface disturbance and just increasing the downhole recovery.
So, and you know, I think it's important to note too that again, we've tried to be really safe with this stuff. And realistically, if you look at exhibits G&E 17 and G&E 19, this is 80-acre vertical development. This is actually even a little better than what's out there right now, which is 8 verticals per 1280, which is really 160. Now, what you can do is you could say that the under Order 139, 134, the location of those wells, the only gravamen you have is you got to be 660 feet from a boundary. So you could do 80-acre development under the current order, but you could only do it in one of the 2 sections that make up each drilling unit. So I just wanted to note that these exhibits are likewise trying to play it a little safer, so that you can understand that, you know, it's even worse than this now, and we would be trying to make it even, you know, more dense, so that you can actually get those gains and still minimize based on Finley's CH4 Finley's drilling plans. So I'm going to ask Mr. Porter, do you have anything to add to Exhibit 20?
No, I don't.
Okay. So Mr. Atkins, I'm going to ask you and Mr. Porter these questions, both individually. Were exhibits G1 through G20 prepared by you or under your supervision, direction, and control?
Yes.
Okay. And do you believe that the relief sought in the RAA, the increased vertical density and the decreased setbacks to 100 feet will protect correlative rights, minimize waste, minimize surface impacts, and afford a maximum resource recovery?
Yes.
Okay. Mr. Porter, these exhibits likewise were prepared by you or under your supervision, direction, and control, exhibits G&E 1 through G&E 20?
Yes, sir.
Okay. And do you believe that the relief sought in CH4 Finley's RAA will protect correlative rights, minimize waste, surface impacts, and afford maximum recovery?
Yes.
Okay, thank you. I have no further exhibits nor any further questions for Mr. Atkins nor Mr. Porter.
And we'll now go to the division for cross-examination.
Thank you very much. That was a voluminous amount of testimony and exhibits, and I think it is important because this is a matter of first impression that we, the division, can walk through those exhibits similar to what the board did and take them slide by slide. I think there's a lot of information we'd like to unpack there. So with due respect, I think that's where we'll start with L6, if you would. So yeah, my basic question is, how similar are these lands that were addressed in these various matters listed on L6 to the application lands? And specifically, if you could address, are they the same lithology with the same rock properties and the same deposition environment?
Yes, in my opinion, there are similarities between the formations listed on L6 and the formations in the Uinta Basin. There's a combination of multiple formations listed here, and that was part of the message also, is that in the Uinta Basin, we do see varying lithologies. And so it's not, these types of setbacks are not limited to one specific type of rock. And it covers very similar rock types as seen in the Uinta Basin.
Thank you. And are you familiar with the evidence presented in those matters?
I'm not.
Do you think it was limited to merely microseismic data?
I know microseismic data was heavily involved, as well as permeability data and rock type, similar to what we presented here.
And is there additional data that you could use to demonstrate drainage? I believe I'll have to lean on my technical expert here. I believe it's DFIT.
Yeah, DFIT testing.
DFIT testing.
Pat, do you have anything to answer for that?
As far as what would you hope to be obtaining from the DFIT, the reservoir pressure?
All right, I think, yeah, that question will be better directed at a different exhibit. All right, let's move on to G and E1. Excuse me, G and E2. Okay, and G and E3, please. So I'll start with the more lay questions. If you look between Project 1, 2, and 3, specifically moving from Project 2 to Project 1, moving east to west, there's 9 degrees of variance in the azimuth. Is that correct?
That's correct.
And if you were to continue to move west, how do you expect that azimuth, the degrees of the azimuth changing?
I do not expect it to change outside of this variance.
So does that mean it would continue to trend 9 degrees every time you move? I think those wells are those wells about 1,300 feet apart? Is that correct?
They're about 3/4 of a mile.
3/4. So every 3/4 of a mile, would you expect to see another 9 degrees in variation?
No, sir, I do not.
And why is that?
Partially based on other data that I've seen in the basin, specifically the dipole sonic data. But like I said, we based all of our testimony here based on real data seen downhole. There's across this area of the basin, it's very consistent. To see a 9-degree swing from one well to the other is that's pretty minimal compared to the other side of the basin where you see more dramatic shifts.
In terms of Project 1, 2, and 3, are these all drilled into the same formation or same horizon?
No, sir. These are 3 different horizons, and that was meant to relay the 3 different benches that we intend to drill and show that you see consistency across all 3 benches.
Okay, just one moment. I think if with leave from the board, I think it would be beneficial to have more of an expert to expert discussion on this, if that's
Proceed.
allowable.
Please identify yourself and your position.
Dustin Doucette, petroleum engineer for the division. Just a question on the Project 1, 2, and 3 microseismic data on this exhibit. Project 1, was that, do you know the timing of these wells and how they were drilled? Project number 1, was that one of the first wells drilled, or?
I do not know those dates offhand. that's something I can easily provide. But all of these wells were drilled within the last 3 years, roughly. So they're all fairly new.
Okay, so kind of a follow-up to that, and you may not know that. If well number one was the first drilled, would you expect any of the additional wells, future wells to be that azimuth to be affected based off of maybe some depletion in that well, or just based off of timing?
No, sir, I do not. We have other operations in the area where wells drilled on this, much tighter density than these two Project 1 and Project 2 wells, and we did not see any interference in offset wells.
So not even saying between Project 1 and Project 2 wells, the offsetting well to like Project 1, those nearer wells, you wouldn't
Correct.
expect any interference either?
Correct.
Okay, thank you.
I've got a question. My name is Ellis Peterson. I'm another petroleum engineer for the Division of Oil, Gas, and Mining. You've got the 3 projects, and you averaged the results from the microseismic for each of them. Do you know how many stages were actually measured in each of the 3 projects? I mean, each individual well, were there 4 in one, 5 in another? Do you know those numbers?
I know Project 3 was 15 stages. It was the 15 stages closest to the heel.
Was microseismic, was microseismic measured for each of those 15 stages?
Yes, sir.
Okay.
Yeah, 15 stages that had microseismic measured.
All right, let's move on to
Those-
GD.
I was just going to add that all of those stages are the ones depicted on slide G&E 4 and 5.
Yeah, thank you. We might have some more questions there. Do you know how many stages were actually measured in projects 1 and 2?
I don't offhand.
Okay, thank you.
All right, let's move on to GD 4, please. All right, so please direct your attention to the diagram on the right-hand side of the slide. I know you've talked about it at length, but there's a lot of information going on there. A rainbow of colors, various arrows, 3 different lines. Could you just talk about each thing in particular so we can get a better understanding of what this is actually describing?
So the 3 different lines represent 3 horizontal wells that were drilled. The one on the far right, they were not able to get production liner to the bottom of the hole, so that well was temporarily abandoned, and the vertical interval was used as a listening well, which is where that gray kind of star cluster is near the heel. The well in the middle is a Wasatch horizontal well, and that is the well that is being fracked and measured, depicted here. And the well that's sort of on the left is a Uteland Butte horizontal well with an array of geophones right there in the heel section in order to measure the last 15 stages. So it's stratigraphically approximately 250 feet higher than the Wasatch well that we're measuring. And so using that horizontal well at that distance close to the actual stimulation job, as well as the array of geophones in the heel and in that where that gray star cluster is, they were able to triangulate and get a much more clear picture of what events are actually happening. Each color represents events that were measured in a particular frac stage. And the arrow is the interpretation of the ESG geophysicist on depicting the orientation of that stage. And so for this particular well, as I mentioned before, the full fracture azimuth was north 88 west, but the connected, what they call the connected on zone fracture extent was the north 83 degrees west. So north 83 degrees west represents the average of all of the black arrows shown on this slide.
Would you happen to know the minimum and maximum? Looks like there's quite a bit of variation between the arrows, in terms of the fracture azimuth. It looks like some are even going the opposite direction. So do you have an idea of the variation between the arrows?
I do not know the variation, but it appears to me to be only a few degrees, very minimal degree change in my opinion. Some of them are actually flatter than the 83 degrees west.
And then drawing your attention to the bottom left, what is the scale of that diagram?
The scale of that diagram is the measurements that we've mentioned already. And so the upward height growth is 163 feet. And then the east and west fracture half lengths. And so this well was 215 feet. 215 feet. And so that gives a three-dimensional image of what those events look like along the wellbore. And the blue, the darker blue, is meant to represent the perforations that are within that stage. And so you really see that it's not growing. And on the kind of towards the left, also right through there, the light blue, that's the events on the perforations on this stage. So you see that it's not growing heelward or toward outside of this stage. And so that's your defined stimulated reservoir volume. It's a little bit of a three-dimensional picture trying to put together all the other numbers and data that we discussed.
All right, and then the rosette plot on the bottom, what is the scale as you're stepping out from that?
So the rosette plot is actually tying back to the image on the right. The rosette plot is the orientation of all your black arrows in one place. So that's your degree of variation in angle, and the distance from the center is the number of times that it occurs. And so the thicker, the wider it is, the farther away it is from the center, is more often that it has occurred.
Thank you.
Is there a toe frac here? Because that wellbore seems to extend down below.
Yeah, you go for it.
On the diagram on the right, you say you got 15 stages here, and it looks like the well extends quite a ways south beyond. Is there an actual toe frac here? Is the toe frac the last one you show there? Is that included in the microseismic?
No, sir. They when this data was gathered, it's expensive. It's very expensive, and so the only data that was gathered was the last 15 stages closest to the heel, and that was also partly because that's closest to the vertical listening well, and the vertical listening well had geophones above and below the target interval, and so when you have phones above and below the target interval, as well as above in another horizontal well, an adjacent horizontal well, you can get a very good three-dimensional picture. And so the further away towards the toe that you get from that vertical listening well, the more distorted and the less reliable the data was. So the most reliable data was those 15 stages closest to the heel.
Okay, thank you. And one other question, the little diagram on the left, which is the green dots showing the dimensions, the width, would that characterize the total fractured rock volume or altered volume for that particular stage? Is that the width?
Yes, sir. That's the intention of that measurement.
Do you know how wide that generally is for a stage? Was this like with 3 sets of perforations or 5 being in the Wasatch?
So that's this particular well had 12 perforations, and they did not see growth outside of their perforated interval. And so there's kind of leading into what I mentioned earlier. There are techniques, and there's depending on your stage length and your cluster spacing can really impact those frac half links and that cluster density. And so CH4 Finley plans to do what we need to do to maximize the near wellbore stimulation to limit the long fracture growth outward. So we want to limit long fracture half links to make sure that we're not bypassing pay that's already near the wellbore.
Thank you.
Mr. Kissinger, I just wanted to add something that I want to make sure that the board is clear on this, because it could get confused. Where I have the arrow here, that's not the toe of the well, right? Like is that correct? Like this is just that heel where they were actually monitoring. This well keeps going down off the paper, correct?
Understood.
Correct.
Okay.
All right, and let's go to G&E 5. And G&E 6, please.
Like probably. That's where the toe is. Right.
We move to slide G&E 6, please.
Yep.
We both have questions on this. By all means.
Go ahead.
Dustin Doucette again for the division. So on this core data, could you tell me what kind of core that was, and how that was gathered? Is it like whole core? Is it sidewall cores, or?
Right. So this is whole core that was taken in these two wells, and then the data points that you're seeing are plugs that were taken out of that core in order to do this analysis. So you take an 1.5 inch plug out of the whole core to run permeability analysis on.
Okay, so you didn't do a whole core analysis on the actual core. Then you took plugs out of it.
It is the whole core analysis, but you can't run. It's cost prohibitive to run permeability on several hundred feet of core. So these points were selectively chosen at the time to represent different changes and different intervals throughout the zone. They're kind of equally spaced throughout the zone.
Okay, so the core wasn't oriented. You didn't run an oriented core in any of these examples?
I personally did not run this core data. I would have to go back and check and see if it was oriented. But to my knowledge, I don't remember.
And you didn't run any analysis on the full core as far as the whole core outside of the plugs. You didn't do a directional analysis on permeability, minimum and maximum.
No, sir. And that's the most common data that I'm used to seeing is the plug analysis for permeability.
Do you know if this had when you viewed this, did this have some natural fractures that may affect these permeability numbers, in your opinion?
In my opinion, it does not.
Does not have any natural fractures that would affect that?
Correct.
Okay, thank you.
Ellis Peterson with the division. Have you done any, this is relates to a question Mr. Kissinger asked earlier about defect tests. Have you done any defect tests to get permeabilities in situ to verify these low permeabilities?
Are you just referring to doing a permeability test under pressure?
Well, I'm talking about, what I'm really asking, have you done any pressure transient testing or any diagnostic fracture injection tests or other types of transient testing that might lead to an analysis to give in situ permeabilities for these rocks?
I have not been a part of that. I have not done that testing. This permeability here was calculated from the plugs using the Klinkenberg method for fluid flow.
Okay, another question along those lines, but again, looking at the engineering, this might be a question more for Mr. Porter. Have you done any of the simple calculations for radius of investigation? I know some people use that calculation to try spacing their fractures, but you can do a radius of investigation to see what rock volume or how far out you might influence the pressure or rock. I was wondering if you've done any of those calculations, even with these low permeabilities, to verify that you wouldn't affect anything more than 100 feet away.
Specifically, I'm not aware of any analysis like that.
Okay, thank you. I have.
All right, and we'll keep this moving to G7.
Radius of investigation. Okay.
Mr. Chicken, if you'd advance to G and E11, please.
Yeah, Ellis Peterson with the division. Okay, let's talk a little about this volumetric drainage map, if you don't mind. You mentioned here that your stage spacing is 150 feet. So in a 10,000 foot well, you're going to have some 67 stages. Would that be accurate? Or 67 perforation intervals?
That would be frac stages.
Frac stages, actual frac stages. And each of those frac stages would produce an elliptical shape. Is that a reasonable assumption, since your toe and your heel stages?
No, I don't believe that. I believe that with each stage, with the fracture design that we're coming up with, because it's not single point of entry, that we will see fracture growth, because we're going to be bound within that fracture stimulation. So it's going to be accommodating essentially the stage length.
Okay.
You may be getting a little growth back towards the heel, but again, like I referred earlier, 75 feet, the reason for that, utilizing that number, if we believed that we were getting that much growth, we wouldn't be doing 150-foot stages.
Okay. You mentioned, I think, a number of times that you only can produce what your frac touches. From the microseismic data, are you looking at complex fractures, kind of like tree root, dendritic type fractures? Is that how you guys envision it? Where here we talk a lot about, your presentation would indicate it's a planar, more of a planar fracture for each of these perforation stages. Do you guys have a feel for what kind of area you're actually fracking and the volume of total fractured rock you have, or stimulated rock with each stage?
I wouldn't characterize it per se as dendritic. What we're trying to do, essentially, with other companies I've been with, we call it rubbleizing.
Okay.
We're trying to literally break up the rock in as small pieces as we can.
Okay. And the 75 elliptical growth, your aspect ratio, I think you've said, what's the source of that aspect ratio in the 75 feet?
That's utilizing the calculation of the 75 feet. Observed aspect ratios that we've seen have been 3.5 to 1 to as high as 8 to 1.
Okay. And where have you observed those aspect ratios, or how did you determine those aspect ratios?
We've seen it off microseismic.
Okay, so that's coming off of your microseismic data?
Yes.
Okay. All right, thank you.
If you would advance to G&E 12, please.
So you mentioned only what the fracture touches, that's the volume of rock you're going to produce, and that's the source of your 75 feet. So on G&E Exhibit 12, this elliptical shape would represent kind of a rough average of the total rock volume, stimulated rock volume for a well, is what your assumption is for that?
No, this would actually be representative of, I guess the best way to describe it is we believe it at the heel and toe as portrayed on GE 11, that one half of the ellipse represents the toe, one half represents the heel. But just using for the calculation of the ellipse volume.
Okay. All right, and like I said, I was trying to get back at that, where that 75 feet came from. And this calculation would indicate that at the closest point to the unit boundary would be some 22 feet, 23 feet, is that correct?
Yes.
Okay, and your azimuth direction, you've got 85 degrees. Did you run any sensitivity to look at how much that would have to change with the assumptions shown here to actually drain or cross over into the next unit boundary? In other words, do you know how much that orientation would have to change in order to move this elliptical shape into draining the neighboring unit?
I ran some different numbers as we were developing and as I was building out this spreadsheet, but I don't recall specifically what that number was.
Okay, thank you.
So maybe I can ask the same question, but in a different way so I can understand it. So if that angle was, let's say, 75 instead of 85, how much closer would we be to the 100-foot setback? And would we be over it, I guess, is another way of asking it.
Specifically, I can pull out my laptop and I can answer that in probably 10 minutes.
Okay. I think, yeah, I'll actually ask that question to Ellis Peterson in a moment. Any further questions here?
No.
Any further questions for any of the exhibits?
Yeah,
The 22 feet would go to approximately 65 feet at 75 degrees.
At 75 degrees, south to east.
Correct. The number, the Y number that's 22 feet would become 65 feet.
All
at
right,
75
I'm sorry.
degrees.
I'm asking about what would it be your 100-foot setbacks subtracting your Y prime. So the closest point this ellipse gets currently, according to the assumption you show here, is about 22 feet. Don't be confused with the 22 feet actually shown on the diagram. In other words, that would be 100, say 100 feet subtract 78 feet at the X equals 50.
Right.
That would represent, you'd be 22 feet from the unit boundary. And some sensitivities of this might realize that, say you have 75 degrees, that's possibly when you would cross over that unit boundary, according to similar calculations checking this exhibit.
I think we would have to run the calculation, but based on all the data that we have, that's not a concern.
Okay. Thank you.
Thank you.
Before you leave that, let me ask a question.
It's not to scale.
Mr. Chicken, when you're ready. I have just a question I want to make sure I understand. So if you had empirical data that was not needed no legal or no expert opinion, if that ellipse touched the line, I'm talking about a hypothetical.
You're talking about
What I'm trying to, I'm going to.
ellipse touching the
We've
line
got to
down
have
here.
the wisdom of Solomon in that if the ellipse touched the black line on that exhibit, you would be protecting correlative rights because you didn't cross the line, but you'd also be avoiding waste by not leaving any production behind. Is that?
That's my understanding, and I'd also note over here, you see this 22 feet? It's not the scale. There's 100 feet between here and here. This line should be about that big, but you can't fit this big ellipse with all the numbers inside of it on the cartoon with that proper scale. So, in other words, there's 78 feet in between there is what I'm saying.
What we're trying to do is, if we were, have the wisdom of Solomon, we would want to get as close to that line as we could without going over it. That line being the boundary, the unit boundary.
Correct. From a purely technical standpoint, no waste would mean the ellipse from the north and the ellipse from the south both just nudge right up against that line and don't go over it. But obviously, we're playing a lot safer than that.
Mr. Messenger, do you agree with that? And your experts?
In terms of
weighing correlative rights versus absence of waste. Isn't that sort of the ideal scenario?
Yeah, in my mind, the board is charged with balancing resource recovery with the protection of correlative rights, and that is why setbacks were set conservatively to begin with. If in a perfect world you could mirror the setback to be, or mirror the drainage area to be perfectly in line with the setback, then the board would be perfectly discharging its duties. However, as we know that this isn't exact and we're working with averages.
And so there's a safety factor.
Correct.
That we're building into this, and the safety factor is the difference of 22 feet, or 100 feet minus 22 feet is 78 feet, and that's your safety factor that's built into this. And at some point,
average,
you're going to be. And the safety factors for correlative rights, but it also diminishes the optimization or the avoidance of waste.
Yes, I think exactly. I think the
board members,
do you
feel like you understand that this balancing? Rights. Susan, do you have a question?
I was just going to say, if the ownership on the north and south were the same, we wouldn't care, because there would be no correlative rights. We would just want maximum recovery, which is why we're not arguing about what's inside the red line. So we're setting a precedent about how close to that red line we can get. I would personally love to hear from other operators and producers and owners of mineral rights close to that boundary line, because I think when we've argued about this relative to other things, if in their portion they would also want to get to be within 100 feet, then great. I mean, everybody, let's assume that it does cross that line at some point. Do we really care if we're maximizing production as long as all producers in the region can agree on 100 feet is what I'm saying.
Or if it goes over the line, is it de minimis or is it material?
Correct.
Okay. I'm going to ask at the end of this if we have any comments from the rest of the audience, and I'm hoping other producers or their attorneys will comment. Okay, I'm sorry to take time, but I thought it was important on a case of first impression to understand this balance that we're trying to get to. Okay. We're back to you.
I believe Mr. Barton had a question.
Oh, I beg your pardon. Mr. Barton.
If one of the concerns is how the stress field varies across the basin, which it appears to be, we have seen in past testimony stress field maps covering the entire basin showing how the stress field varies geographically. Would it be possible? Are those kind of maps publicly available to see where this area falls on such a map?
I don't know that those maps are publicly available, but we can provide more data from that standpoint. I think the focus here at Rocky Point is that the microseismic tells us what the actual stimulation job does downhole at this location, and that's really the primary focus that we're looking at today. But I'm happy to provide more information after the hearing.
Mr. Kissinger, just to see if I can't speed this up a little bit. All of our horizontal drilling in the last number of years has been part of a pilot project where we encourage this kind of analysis, this kind of test level, but it also means that the order has a shelf life of 5 years unless extended. And it also requires annual reporting of lessons learned and things like that. If we were to do this under a pilot project, or just an extension of our existing pilot project, would that lessen the number of questions you have to ask, or do you feel like you're learning the same time we're learning?
I would respond that we want the board to be making its decision based upon the best information possible. And I believe Mr. Peterson has described at least 2 other methods that could provide the board with better data. Specifically, this is the benefit of the DFIT testing. And
Okay, and
also
describe
doing
what
the
DFIT is
radius.
so the board understands, because that's a term I haven't heard before. And then sorry to interrupt you, Mr. Kissinger, just let's take one at a time. What is a DFIT test? In your view, Mr. Ellis, and then back to the applicant, what was your interpretation of a DFIT test?
Well, DFIT, I kind of lumped it in together with a pressure transient test. A pressure transient test is where you have pressure gauges and you look for minute changes in the pressure, and there are analytical methods to determine things like reservoir permeability in situ with those tests. DFIT is one they do. It's an acronym for a diagnostic fracture injection test. I think it's copyrighted by Halliburton. But a lot of people run DFITs trying to understand the leak off, the permeability. It's a step they take early in the process of designing fractures to get a better handle on exactly how they want to fracture stimulate something. And one of the pieces of data that comes out of that is a permeability, and it's such a common test. I thought maybe they would have some collaborating permeability data from that. You know, as far as trying to get a definitive test here, you know, something as simple, well, nothing simple in the industry, and especially with these complex wells, but where you have 2 stages, say 200 feet apart, and monitor pressure in one while you pulse the other one. You pressure something and look for interference. That would be much more definitive information than what we've seen from the microseismic, some of that. And it's going to vary by formation. So that's what we were talking about with DFIT. I would lump it in with a group of tests called pressure transient test.
And
thank you for letting us.
Mr. Peterson also identified another calculation that was called the radius investigation, and if you would speak to that as well.
Why don't you explain what that is for the board?
Well, you see it. There's a consulting company called Bobbery and Associates, and it's even some of their paperwork. But it's a standard reservoir engineering calculation. They're looking to see the volume of reservoir affected, or the distance that reservoir is affected. Part of it goes back to transient testing. So if, say, I pulse a well, or I produce a volume that causes a pressure transient within the reservoir, there's a certain time that pulse is going to go out in the reservoir. In other words, and you can reverse it and say, okay, say I start producing, how long does it take and how far will I be as a factor of time? And there are the parameters in that calculation. Their permeability is one, and there's compressibility of the fluids, porosity is involved. There's a number of these factors, but you can take even those low permeability and say, okay, if I start producing with time, it's just a calculation, how far out in the reservoir you'll see an effect from a change in pressure over a period of time.
Any comments from the applicant? on what we just heard. Do you concur with that? Is it cost prohibitive?
I have a question. Is your primary goal to get better permeability data for these tests? And how, in your opinion, does it differ from the permeability data that was presented? Because the permeability data that was presented was measured from the core data, and shows, micro Darcy to nano Darcy perm, which to measure fluids, moving through that sort of permeability is very, very, very slow. It's geologic time almost, instead of the life of a well. So I'm just interested in what specific data compared to what we presented you're trying to get to.
One is to make sure we have the best in situ permeability data. Core data isn't always representative. Rock, you've got how many points trying to represent how many acre feet of reservoir, where in situ measured permeabilities average all that permeability together, I think give you a better idea. And quite frankly, the simple radius of investigation calculation would indicate that you're affecting rock, maybe not tomorrow. You said geologic time. The numbers say, okay, maybe it's in a year. And then the question becomes, is that balance? Do we care if it takes a year? We don't know how much flow is going to come from that point. But there is a point out there where if you're affecting the pressure, if you're seeing pressure at a distance, you've had flow corresponding to that pressure. Question is, how much flow have you had? That's another debate.
We're going to bring it back to the board here. Mr. Church, you have a question.
Yes, Mr. Peterson, are those pressure transmission tests valid after frac, or they're only valid pre-frac? When are they run?
You could run one after a frac. It just becomes difficult. The interpretation it changed. There are other things. That data can go into reservoir modeling and many other things to try to verify this. A reservoir or a numerical simulation of both the way the fracture extends to try to match that to the microseismic data is something you can do, and then you can do a reservoir simulation to make sure that all the physical parameters involved here, such as compressibility, permeability, the rate, the pressures, all of that, that they're congruent with one another, that they all make sense. And, that's another thing you can do here. It all costs money and it all takes time.
But these are commonly done pre-frac more often than post-frac.
Well, many operators like to run a simulation to see the effectiveness of their fracture stimulations in their development plans.
Okay, we're going to come back to Mr. Kessinger and your crew on the next exhibit, if you're through with this one.
I believe we only had 2 further questions. The next exhibit is G&E 14.
The only question I have here, you've mentioned the aspect ratio. I know it varies from 3 something up to 8. I think Mr. Porter said here. I just want to point out you've extended the fracture half length to 504 feet, but you maintained the 75-foot minor axis. If you went with that same aspect ratio that you used on the other one, say a 4, then you're out 125 feet and you have crossed that boundary. Is that correct?
No, I don't think so, because again, the 75 feet is an assumption. It's a half of a stage length. And again, if we believe that it was anywhere beyond that, and honestly, I keep saying I believe it's measured in feet, not even tens of feet. So doubling the fracture half length would not necessarily extend, and that's one reason bounding that on the aspect ratio.
So the aspect ratio at 504 feet would half? In other words, you talked about an aspect ratio.
Right. So what that would do is actually increase the aspect ratio. You would have more growth in the frac length, but no additional growth in the width.
Okay. One other question. So if the board were to allow this reduced setback and somebody, the neighboring operator, came and drilled a well to within 100 feet of the drilling unit boundary away from you, say after you've had your well producing for a year or two, and so you've had some depletion, but you haven't crossed the line, would that depletion affect the in situ stresses such that it might benefit or it might be adverse to the neighboring operator? But would there be any effect to the other operator by a change of in situ stresses and their ability to frack their well?
I think the basic answer is no. I don't think there would be significant changes enough that would change that fracture. In other words, what you're describing is, would that preferentially cause that fracture to grow in that direction? And the problem that I see for something like that to occur, it's got to go through all this other rock that's basically the setback, that it's going to have to overcome that, and it can't do that.
All right, thank you.
All right, thank you very much to the board and to the expert witnesses here. That concludes our questioning.
Board, any questions of these witnesses? Okay, then we are to the division for your case in chief.
Chairman Gill, can I ask a question?
Yes, of course.
It's more answering your question. When he discussed pilot orders, what we're requesting here could literally be amended or could literally be accomplished by taking the two existing orders, crossing an 8 out, writing in a 32, and crossing 330 out and writing in 100. In other words, the orders we're trying to amend are both already pilot orders with 5-year sunsets and annual reporting requirements in them. And as we mentioned before, the biggest offset owner is aware of this and has chosen not to file a comment letter or any protest, despite the fact that they were here presenting to this board at 9 a.m. this morning. In addition, we've not received the board hasn't received any public comment whatsoever from anyone on this, despite publication and that type of thing. So I just wanted the board to be aware of what we're asking here is kind of, there's a lot that goes into it, but the mechanical piece of actually changing it's going to be a 2-page proposed order that says change this to that and that to that. So what I'm getting at is everything that's in the existing orders and that's in a pilot order that the board has required in the past to be protective is going to remain if this was approved.
Thank you very much. Division case in chief.
Thank you very much for allowing the extended questioning. After a brief consultation with my client, I think the division is supportive of moving forward on a pilot project basis. However, they are very much interested in getting more specific data about what happens when you have a heel and a toe of a well 100 or 200 feet apart, if that's where we're reducing the setbacks. So we expect to get information specific to that question by this time next year. And so again, we're generally supportive, but I would also like to entertain comments from any other members of the public or the industry that are in this room right now.
Why don't we go to that point, Mr. Chicken? Would you object to that if we went to the public?
Well, look, I mean, I guess I can't prevent the board from exercising its discretion, but we don't give them. If there's other parties that want to comment, I think the board can
give
the
it the weight
information
we
it
deem
needs from that.
appropriate.
but
I
there's
think we
there-
understand
There's a
that,
distinction between a party and a comment, and that's all. That's
and
what I'm
that's what
saying.
we're taking. So is there anyone in the audience that'd like to make a comment? Please introduce yourself and who you represent, or if you're speaking for yourself.
Thank you, Chairman, members of the board.
Closer to the mic, please.
Thank you, Chairman, members of the board, Mr. Chicken, the CH4 Finley team, and the division. I know this has been a long hearing, and I am not trying to interject myself. My name is Mitch Mayo of Lear & Lear PLLC, and I'm here on behalf of Bainbridge Uinta LLC. And we would like to comment with respect to this. I would like to remind the board that this is a public hearing, and the entire purpose of this hearing is to receive and consider public input. And so to the extent this comment will be given any weight, I hope it will give them the weight that any public comment would be due in a public administrative hearing. With that being said, this is incredibly dense, and I would like to try and go through it kind of the way I have designed. If the board would prefer to interrupt and ask questions, please feel free to do so, obviously. The reason Bainbridge is here today is something that Ms. Davis brought up several times, and that is that the board is doing something that today, they're considering something today that may have precedential effect. The board makes it clear that they do not apply precedent order to order. Because a 100-foot setback is ordered in this cause does not mean that I can represent the company next door and say, we're entitled to it as well. That's not the way precedent applies, but it is letting the camel's nose into the tent. This is the beginning of this, and what Bainbridge wants to be clear is that there are or may be unintended consequences from doing something like this. Until just a couple days ago, Bainbridge, there were two matters to be heard today that both contained a request for reduction in the heel-toe setbacks. The present matter brought by CH4 Energy Finley, Utah LLC, and a request in cause number 470-01 brought by Finley Resources, Inc., and I'll call that the Finley request. Bainbridge is a party to the Finley request and timely filed a response and exhibits in that cause. Bainbridge was prepared to present its case today, but Finley's counsel moved to continue it so that the parties could attempt to amicably resolve any differences they have. That matter has now been continued, as the board's well aware of, to the March hearing. So I point that out to essentially put the board's mind at ease. Bainbridge is not an interloper. Bainbridge is not someone who sat around and just thought, I will make a comment. Bainbridge has a vested interest in ensuring that not only science drives these kinds of decisions, but also that the board doesn't enter an unintended consequence that then later affects Bainbridge's vested rights as a party in an active matter before this board. Historically, as has been discussed, the board employs conservative setbacks. 330-foot heel-toe setbacks are those conservative setbacks, and they are conservative. I don't disagree with the evidence presented necessarily that there is room to expand those setbacks in certain DSUs and certain amounts. What Bainbridge has concerns with is that the evidence presented hasn't allayed the concerns that this is a step too far. If we're looking at incrementally increasing setbacks, that's a discussion that should be had. If we've got definitive science or more definitive science that says we can take large steps towards the setbacks, then that's a discussion we should have. But what we've got here, I think, is kind of a mix of the two. And I'd like to go through a couple of the exhibits kind of briefly if I could. There's been a little bit of discussion about Exhibit L6. That's the exhibit that CH4 presents that discusses or lists the drilling and spacing units in other areas. I'd like to note just a couple things about that exhibit. One, the vast majority of those orders are in the Permian Basin down in Texas and New Mexico. That is a very different basin than the Uinta Basin. It has geologic similarities, and I don't put myself out as a geologic expert by any stretch of the means. But from my understanding, they are different basins. Second, that exhibit just shows us that these orders exist. What it doesn't show us is, it doesn't show us what the geologic or operational concerns were. It doesn't show us whether these DSUs were temporary, aside from the statewide, field-wide examples that were presented. And it doesn't show us whether they were based on some type of compromise or agreement between parties outside of the hearing, which happens occasionally in front of this board as well. And finally, it doesn't show us what sort of scientific evidence was presented to those commissions or boards to justify those setbacks. Lastly, on that exhibit, in some respects, 100-foot, a lot of those jurisdictions, New Mexico, for example, they had 100-foot statewide all formation setbacks. In some respects, that to me makes a little more sense than selective 100-foot setbacks. If it's a statewide rule, everyone has the same rules, everyone's playing by the same rules, everyone has the same protections, and it's up to each company to protect their interests. In a situation where you're expanding setbacks and starting to extend setbacks, there really is a need for the board to do so conservatively. And the reason is because a mistake, a miscalculation, a misinterpretation of data that can be interpreted in many ways could lead to the possibility, the very real possibility, that the board is giving a competitive advantage to one operator over others. In addition, as Ms. Davis pointed out, if the ownership is the same on either side of the line, it may not be as big of an issue. However, the mineral ownership may not be the same on either side of the line. And so, as Mr. Chicken pointed out, and is absolutely right, Ovintiv is aware of this. They are the majority working interest owner on either side of this line, and they, as yet, have not made their voice heard. That is a fair representation. What's important to remember is they're really the only major operator in the basin who was notified of this request. They're the only major operator who is on either side of the notice area. And I don't mean to paint anything nefarious. This is absolutely standard practice. CH4 Finley did everything absolutely right, as did Mr. Chicken. The point being, with something like this, it almost is akin to Axia coming before the board and asking for a request for agency action to have operatorship declared. At some point, there was a discussion and a realization that this maybe isn't appropriate for the request for agency action stage. Maybe this is something we should consider in more detail with more voices at the table. And I think that's kind of where Bainbridge feels this is right now. As part of its comment, Bainbridge would like to state very clearly, pardon me while I get some water, that science, as the division has stated and as CH4 has presented, that science should underpin setback decisions. And this science should be presented in sufficient detail in the exhibits so that it can be analyzed, digested, and either confirmed or refuted. Because of the way this case has progressed, the division submitted its technical memorandum late, and CH4 was forced to submit supplemental or amended exhibits late as well. And so the board, the division, Bainbridge, and the public in general have had about 48 hours to digest what we, who work in this field, have spent hours discussing. And I think that might not be enough time for the public to give clear, informed input. Now, we all know the public doesn't participate in these hearings nearly as much as we wish they would in some ways. But the fact remains that there is some sort of necessary safeguard there, that the information be presented in a way that can be verified prior to the hearing so that parties can make real decisions as to whether they would like to participate in hearings to address the concerns. So science should underpin any spacing decision. To be clear, Bainbridge is not opposed to the amended exhibits submitted by CH4. Bainbridge's position is those exhibits are necessary, they are good exhibits, and they should, in fact, be considered by this board when it makes its determination. Bainbridge's concern is whether these exhibits are sufficient technically and also given in enough time for this decision to be made, having digested everything and thought through it. Therefore, Bainbridge wouldn't suggest necessarily denying this request as it relates to the 100-foot heel-toe setbacks. But what Bainbridge would suggest is a continuance of that portion of the request to the March hearing. Now, this can be accomplished in one of two ways, neither of which Bainbridge has the ability to
I'm going to
control.
object at this point. We've got an attorney asking for the board to continue a matter that his client is not a party to. I'm all for comment, but there's requests now that are happening. So I'm going to object. I mean, my understanding is Bainbridge owns no interest whatsoever in the subject lands or in any of the buffer notice zone. So
That's absolutely correct. Bainbridge does not own any interest in the subject lands or in the buffer zone that I am aware of. Bainbridge is a member of the public and is an operator in the basin and thus has an interest that should...
Take your comments. We'll take what you're saying as comments, but when you get to the point of asking for board action without being a party, I believe Mr. Chicken is correct.
Sure. Well, the couple points of clarification, and not to get too far afield, but Bainbridge would like to comment on the availability in the rules of the division being allowed to move to continue a portion of a request, or the board on its own motion to be allowed to do so. Bainbridge believes that this is the best course of action because it does not, I'm sure CH4 Finley would disagree with this statement, but it does not prejudice CH4 Finley to continue this another month. Obviously, there is a hassle and an inconvenience, and I have had hearings continued as well, and it is not the preferred course. But this is not about necessarily knocking this request out. This is about having time for everyone to get their arms around it. After 4 hours of discussion, the division, their position evolved. I think the board, some of their positions evolved on this. I know my position did sitting in the audience. And I think more time is necessary to discuss this. A couple of details about the comments. To the extent that the exhibits have been examined by Bainbridge, I'd like to point out just a couple points of clarification. I believe it was Mr. Borden who made a comment about CH4 Finley is representing that the azimuth is essentially flat, north 85 degrees west, which is clear, and that is the average azimuth across these microseismic data wells. The comment was made, if you were at a 50 degree, you'd probably be in trouble, and that was absolutely a valid point. What I would like to point out on behalf of Bainbridge is that the rosette plots contained within the exhibits show a significant amount of variability in that azimuth. Upwards of, by Bainbridge's calculations, 30 degrees. And so that does make a significant difference. Similarly, the data submitted shows that the frac half lengths vary wildly, and some of that testimony here clarified that. Some of it, to be honest, made it a little more confusing to me, but that could just be because I'm running out at the end of the day. But third, between those three starred microseismic wells within the lands, there is huge variability, 190 to 340 feet as the half length, and a 10-degree azimuth change. And that's just from those three. And so it's important for the board to remember that what CH4 Finley has presented is a very good, very complete case that shows a very good, probable technical model. But what Bainbridge's position is what they have not done necessarily is convinced yet that model is as contained or as definite as it has been presented. And Bainbridge believes that more time would allow everyone to digest the information in a way that feels better, so the board can make an informed decision and avoid any unintended consequences from an exception such as this. I'm gonna try and wrap up. First, I'd like to say I sympathize with Mr. Chicken. We are attorneys. We represent our clients. That is our job. Mr. Chicken is not here saying he believes 100-foot setbacks are valuable. He's here saying CH4 Finley believes 100-foot setbacks are justified. I apologize. His microphone was turned off, but he said...
I'm sorry, Mitch, but to clarify, I am saying exactly that. They've convinced me for sure.
Okay, good. Well, I stand corrected. It is just me. The point being, as attorneys, we would love to be able to say to you, I will say in this matter, no, and in that matter, yes. That's just sometimes the prerogative of being an attorney and having to represent your clients. I may very well be standing up here, sitting here in front of you in the future, doing exactly that. But in that request, as in all the requests this board has faced, the technical data and the technical data alone should justify the granting or denial of the request. Put simply, to sum up, the Bainbridge believes that the presentation today was very impressive and has lots of information. Bainbridge also believes that it has yet, as a member of the public and as an operator in the basin, had sufficient time to digest that information, and for that reason would welcome any opportunity to consider the information in more detail. Thank you for indulging me.
Thank you, Mr. Mayo. I think we're at the point where the board can ask any final questions before closing argument. Is there someone else here? Oh, please, come. Just make sure you sit, when you speak close to the mic and introduce yourself and who you are. Your phone is not on yet.
Thank you, Mr. Chairman. Danny Gunnell, Wasatch Energy Management. We just want to, we'll be super brief because this is taking a long time, but we do have an interest in this area and just want to be on the record that we support the pilot for the 100-foot setbacks.
Thank you. Anyone else? Seeing none, okay, board, unless there's some second thoughts or some additional things, what I thought we'd do is we'd ask the final questions of the board and then go to Mr. Chicken for closing arguments. Thank you, Mitch. Is there anyone that's got a problem with that process? Let's bring this to a conclusion then. Where do you, Mr. Chicken?
Thank you, Mr. Chairman. We have been doing this for a while now, and I think everybody understands what the request is. As I noted, these are going to be amendments of existing pilot orders. We're literally changing numbers in those orders and nothing else. All of the existing requirements will remain. I believe a couple of key things here are the board should be considering. Number one, I believe we've fully met our burden under the statute to prove that this is going to protect correlative rights. It's going to prevent waste. It's going to prevent waste that is almost unpreventable in any other way. That the parties that have received notice about this and actually own either, thank you, sir, support us or know about this and aren't moving forward. And I'll also note that we noticed the tribe as well, who owns 65% of the minerals under these lands. They had no right to notice. They're, in this particular situation, but we noticed them anyway to see if they had a problem with it either. And I think one of the things that was mentioned is the answer to it is exactly. There is one other major producer that owns in these lands, and they know about this, and they're not taking any action on it. So, without just beating the dead horse here, I think we've met our statutory burden. We would request that the board approve our request for agency action to increase vertical density and decrease only horizontal well setbacks, and do that via amendment of orders 139, 134, and 139, 158. Thank you.
Thank you, board members. Let's retire to our deliberations, and we'll be back shortly. I took it as they waived that.
Yeah, we don't have any further closing statement. We're well aware of the ability to ask for a continuance. However, I think by moving forward on a pilot project basis and specifically taking a look at doing this type of activity where correlative rights will not be affected, so in the center of the application lands, would be our preference.
Thank you very much.
I don't want to make them, I don't want them to.
Can you hear me? I'd like to go back on the record in about 1 minute or less. Recognize that there's flights out and that we're getting close. We won't be long. Seeing that, Division, are you ready? Make some notes.
I did have a housekeeping item. When we go back on the record, we need to admit exhibits.
Yeah, you haven't done
We
that
neglected
yet,
to
and
do
I've got that not marked, so. Okay, we are back on the record. Mr. Chicken.
I would like to move that amended exhibits L1 through L6 and G&E 1 through G&E 20 and R1 through R3 be admitted to the record, please.
Vision?
No objections.
Okay. Board members, any objections to that? Just got a call. I got to call you back.
Is that on the record? Sure was.
I'm so sorry. There's a technical reason why I got the call, even after I said no, and I'll explain that if you're interested. Okay, the board members, any reason that the exhibits ought not to be admitted? The exhibits are admitted. The board has discussed this, and this is what we would like to do. Number one is to grant the request for RAA. At this time, there was a long discussion about continuing it, but because this is a pilot project, and because it will continue as a pilot project, that under the existing 139-134 and cause number 139-158, that there was some comfort there. We understand that different land situations, different azimuths and things like that, we could go an entirely different direction, that this is a matter of first impression, that we have been concerned as a board about protecting correlative rights to the point that we may have been overly conservative in preventing waste that you presented today, particularly in your exhibit in E15. There was a number of requests from board members and the division that was, the witnesses said, yes, we think we can provide that information. What we're particularly interested in is the sensitivity of the azimuth across the entire area in the request for agency action. Did I miss anything else?
So we discussed that some demonstration that the stress field orientation doesn't change dramatically across the entire area where you're requesting action for, and a little more robust. You did a robust sensitivity analysis around the half length of the fractures and what happens if you double them. It's still okay. Maybe do that same sort of analysis around if the orientation of the stress field changes to by 10 degrees. Are you still okay? Just to demonstrate that.
And to be clear, that would be a supplement to the record and information for the board. Since this is a case of first impression, we're trying to learn as much as we can. With that, I would like to compliment all of the parties involved today. I personally believe that this was the most sophisticated bunch of questions and the most sophisticated presentation we've had in a long time. I'm particularly pleased that the board members and that tracked this and asked questions. The division asked tough questions. We always want to squeeze the lemon and make sure we got a fully informed decision, as Mr. Kessinger said. But there comes a point where we're in a pilot project where you're not going to know a lot more. So with that, Mr. Brown, do you want to say something? No. So Having said that, do you believe you understand where the board's going? And Mr. Chicken, would you prepare the order?
I will. Thank you.
So, I think we missed a step, and that is the vote. So you've heard
just answering
what I said. We would like to have a vote at this time. All in favor, say aye.
Chair, we got to do more.
Mr. Brown, would you make that motion?
Chairman, I would move that we accept the request for agency action with the caveats explained for additional information.
And pilot project.
Yeah, well, yeah, that it is a pilot, a continuation, it's a pilot project, and we need the additional information that we just articulated to you.
Certainly, and I'll work closely with Mr. Kessinger and or Mr. Rowe on the proposed order.
Mr. Rowe.
Oh, that's right. Sorry, Tom.
Does anyone,
I'm sorry, you have a fixture, so I thought, anyway.
Does anyone feel like they don't understand? We need a second, first of all.
I'll second it.
Okay, does anyone feel like they don't understand the motion? Council, do you feel like you understand the motion?
Yes.
Board counsel, do you feel like you understand the motion? All right. All in
Just
favor?
one comment, Chairman. Just another compliment to the division for all the good questions, and just to point, we're going to get more requests for these types of reducing of setbacks, and we would just point other operators to the good questions that were asked by the division as they form their whatever you did today. But you
Best
did a
for
good job.
agency action. Okay. All right. All in favor, say aye.
Aye.
Any opposed?
Opposed?
Okay. Let the record show that Ms. Davis opposed it. Would you like to explain your vote?
Yes, I would. I actually am in favor of reducing waste and am not opposed to the 100-foot setbacks. My only desire is to wait 30 days to see the sensitivity analysis on the angle of azimuth and the stresses in the area of the lands that we're looking at, and I'd like to wait a month to see those. I am not opposed to this change as long as we get that data first.
Let the record show that that was a 5-to-1 vote in favor of it, and the comments are noted. Anything else that we should conclude with this case? Seeing none, then we are on to the next case. Thank you, and we hope you
Thank
make
you,
your
everyone.
flights.
Sorry, I have to go fast.
Mr. Atkins, our best wishes for you and your family.
Thank you, sir. Thank you for allowing me to testify remotely.
Okay, we are in docket number let me start over. We're on agenda item number 4. Docket number 2020-004, cause number 475-01 in the matter of XCL Resources. And the board will be considering the recommended findings of facts, conclusions of law, generated by the hearing examiner for a hearing that occurred on February 11th, 2020. So with that, I believe we'll start off with appearances of counsel.
Gordon Rowe, Assistant Attorney General for the division, or for the hearing officer in this case, actually.
And Mitch Mayo on behalf of XCL Resources.
Okay. I believe it to be the division's responsibility to go first, or Mr. Mayo, would you like to go first?
I don't plan to present anything unless the board needs. I think the division going first makes sense.
Okay. Then let's go to the division at this time.
Great.
Mr. Rowe, you're up.
This is a pretty simple matter, and we'll try to keep it brief for the board. Essentially what happened, and Mr. Mayo can clarify, is the one of the wells that XCL took over from Axia had an issue where it required an exception location to move the well 40 to, or 60 to 100 feet to the side, and that would violate the existing spacing order. So it required an exception location. However, they were only able to identify 99% of the owners in the area when the rule requires 100%. So it required action from the board. We asked, the division directed Mr. Mayo and XCL to request a hearing examiner to expedite the process, and Mr. Rogers was appointed the hearing officer, so I'll turn over to him to present his findings of fact in this matter.
Thank you. Proceed.
Okay, Chairman Gill, members of the board, my name is John Rogers with the Division of Oil, Gas, and Mining, and I was appointed by this board to act as a hearing examiner in exception location request by XCL Resources LLC. It's docket number 2020-04, cause number 475-01 for one of the company's newly acquired horizontal wells obtained through the acquisition of Axia's Uinta Basin assets. The cause came before me as a hearing examiner on February 11th, 2020 at 1 p.m. in this building at this place. Mr. Thomas Kessinger was the Assistant Attorney General representing the division, and Mr. Mitch Mayo represented XCL Resources. There were 3 witnesses that appeared electronically. This matter was a request for exception location to move a drilling path from the established 560-foot setback to 460-foot setback on the eastern border of Section 30 and 31. I'd briefly like to outline the history of this situation. Prior to the asset purchased by XCL, Axia successfully drilled 4 of the 5 wells planned in Section 30 and 31 of Township 2 South, Range 1 West, Uinta Special Meridian. XCL testified that just prior to closing on the purchase of Axia's assets, XCL was notified of a serious technical issue related to the 5th wellbore, which we will determine the failed wellbore. XCL spent weeks trying to determine if the wellbore could be salvaged. It was determined that the wellbore's liner was filled with cement, and an isolation packer set on the backside prevented circulation, and this didn't allow economic production of the wellbore. To remedy the failed wellbore, XCL plans to drill a new lateral sidetrack wellbore 60 to 100 feet to the east of this failed wellbore. However, the spacing order in place for the area prevented XCL from moving that far because the setback was at 560, as established in Order 139-138. Due to the drilling plan that was already in place, if XCL were not able to re-drill the failed wellbore to the east at the same time they were drilling other wells in the area, it would not be economically feasible to return to the area at a later date to drill a new well. The plan was to use the rig in the area and see if there was a possibility to save the failed wellbore. They testified that this option was unlikely but possible. They needed the flexibility to sidetrack to the east 100 feet if the failed wellbore could not be recoverable. An approved and exception location for the well is required under Utah Administrative Code Rule R649-3-3 before an application for permit to drill may be approved by the Utah Division of Oil, Gas, and Mining. In accordance with the provisions of Utah Administrative Code Rule R649-3-3, XCL has attempted to solicit the written consent of all the proposed location of the well for all owners in the oil and gas and hydrocarbons in the adjacent sections 29 and 32 to the east. Despite their best efforts, XCL has only been able to locate and secure a written consent from a small number, was unable to get a written consent from a small number of the unleased mineral owners, of which it was about 1%. So 99% have agreed to this in the offset issue. Therefore, the board action must grant exceptional location and is required to approve production from the proposed sidetrack to the well. Now we're going to talk about your favorite subject here, microseismic well logs, okay, and half lengths. Based on this information that XCL provided, the fracture half length was determined to be 311 feet with a horizontal component of 220. I concluded that a reduction from 560 to 460 would not adversely affect the correlative rights of the owners in the offsetting DSU to the east. In conclusion, based on the evidence and testimony submitted during the hearing, I, in my role as a hearing examiner, find that XCL has proven the requested relief will result in a greater recovery of oil and gas and associated hydrocarbons from the spacing unit compromising Section 30 and 31, and prevent waste and adequately protect the correlative rights of the affected parties to the neighboring DSU to the east. Therefore, I recommend the board adopt the proposed findings of fact, conclusion of law, and the order submitted. If there's any questions, we'd be glad to listen to those.
Mr. Mayo.
I have two quick questions, one about substance and one about process, of quick comments. The first, just a point of clarification, that is absolutely correct. XCL is currently, I believe, right now back on the well, drilling, and their plan, their hope is to be able to salvage the wellbore in its existing location at the 560-foot setback mark. They wanted to get this exception just so that once the rig was on site, if they encountered that problem, they could go around it, and they requested 100 feet again as an excess, only so they could go around in the most prudent way possible. So the plan is for 560 foot. That is the hope. As far as process, I just wanted to point out, this is my first time doing a hearing examiner hearing, and I'd really like to personally thank the division staff for doing all the work to get that set up. That is not an easy process to do, and randomly throughout the month to do that is quite a service. So I just wanted to take the time to appreciate them.
I think we'd, go ahead, Mr. Brown.
John, just 30 seconds or less, how did the process work with so many telephonic?
It was seamless. It was perfect. Not a problem at all.
And I think on behalf of the board, thank you, Mr. Rogers, for acting as the hearing examiner, and to the rest of the division for making this happen, and for your clients being willing to testify on electronic means. Any questions of the board, of the division, or Mr. Mayo? Seeing none, we're back to you, Mr. Rowe, or Mr. Mayor, for closing arguments.
I move that you approve the recommendation.
Yeah, we would do this. We'd move that you approve the recommendation, and there's an order ready for your signature.
I have it here before me. Okay, board members, council has moved that we approve the hearing examiner's findings of fact, conclusion of law, and that the order related to that be signed by me today.
So moved.
Okay, is there a second? Okay, there is a second. Any discussion of that motion? The motion before you, if I've stated it correctly, is to approve the order that is the findings of fact, conclusions of law of the hearing examiner, and to sign the order today. All in favor say aye.
Aye.
Any opposed? Let the record show that's unanimous. Julianne, I have the order up here. Okay, we're moving on to agenda item number 5, docket number 2020-006, cause number 196-50, in regard to the Hinto Energy, Inc. for the Nugget 14-4 well and the Gibraltar 1 well in Grand County, Utah, and as it relates to a request for an emergency order that the board chair approved for emergency seating, pardon me, as the board chair approved. We'll take appearances of counsel this time.
Gordon Rowe, Assistant Attorney General, on behalf of the Division of Oil, Gas, and Mining.
Thomas Kessinger, Assistant Attorney General, Division of Oil, Gas, and Mining.
Seeing no one else even in the room, proceed.
All right. Is the board able to see the presentation that I'm trying to display right now?
Negative.
I'll just wait a moment to get that sorted out. That is an empty room.
Okay, we see it now. Thank you.
Thank you very much. Chairman Gill, members of the board, thank you for your time today. We'll hopefully make this as quick as we can. First, I want to discuss where this matter is procedurally before introducing you to the issues at hand. This matter today is presented to you under emergency authority contained in the Utah Administrative Procedures Act. And the division is asking the board to forfeit the reclamation bonds in place for both of the subject wells and authorize the division to use those funds to conduct reclamation and restoration of the well sites. So just a brief background on this emergency authority. It is contained within the Utah Administrative Procedures Act, and this is the act that provides the backstop authority. So if there's any rules that the board doesn't have or the division doesn't have, this is providing kind of the background rules of process. And this is one avenue afforded to the board and indeed all agencies within the state of Utah. So the emergency provision here is on the top left of your screen. Here, the use of the emergency authority is justified because there has been an oil spill. There's a threat of a looming oil spill at a different well. There is not, nor does it seem there will ever be, a field presence for either of the wells we'll discuss today. And if the division can take a quick action now, they will be better able to protect themselves and make an attempt for cost recovery in the ongoing bankruptcy proceeding. So in terms of what this has meant for the division and for the board, we're operating under an expedited timeline. There has been limited time to object and limited public notice. However, the division has contacted each entity with a readily identifiable property interest, and nobody has objected to the filing of this action and indeed have commended the division for taking such a quick action, specifically the BLM. And so now I'll just provide a bit of background to help inform the board's decision today. On February 11th, 2020, the division received word of an oil spill near Cisco, Utah. The division immediately dispatched an inspector to determine the severity of the spill. Upon arriving to the well site, the division inspector noted crude oil and other fluids draining from a storage tank on site. The inspector tried to contain the spill from moving any further at that time. Several days later, the division mobilized contractors to remediate the spill, which they have done, and approximately 192 tons of contaminated soil were removed. So currently the site is stable, but the well bore needs to be plugged and abandoned and the rest of the surface work completed. And just for reference, the current cost of remediation has been about approximately $11,000. So the BLM was contacted of this action, and they were the party that actually notified the division of this spill. The BLM is the surface owner for the Nugget 14-4 well, which is the site of the oil spill. And so far, they have not provided any financial assistance to the division. There is a chance that the BLM will be able to reimburse the division up to $5,000, but as of today, it's unclear whether those funds were going to materialize, and I can talk briefly about that later. In addition to the need to forfeit the reclamation bond for the Nugget 14-4 well, the site, which is the site of the spill, the bond for the Gibraltar 1 well must also be forfeited as it presents an imminent threat of an oil spill. The Nugget and Gibraltar wells are only a few miles apart, and at last inspection, the Gibraltar well's on-site storage tank was approximately 2/3 full, about 200 barrels of crude oil and associated fluids is in the tank. That tank is the same make and model as the on-site storage tank at the Nugget well and is in similar disrepair. Both of these wells were previously operated by Hinto and are currently undergoing a Chapter 7 liquidation proceeding. And that's part of what makes this situation even more urgent is immediately upon discovering that there was an oil spill from a well operated by Hinto, the division did some quick research, discovered that these wells were subject of a Chapter 7 bankruptcy. We contacted the trustee and the counsel for the trustee for that bankruptcy to discuss whether or not they anticipated sending anybody to respond to the spill. What we heard in response was that there is no capital available to address this spill, and the bankruptcy is currently underway in Colorado right now. That's where the trustee is located, and they had no intention of sending anybody out to address this spill. And further, they had not authorized, nor were they going to authorize any sort of field presence. So, and briefly, there had been some informal discussions about selling these wells, but all of the potential deals have fallen through. And now the best case scenario for everybody involved is to forfeit the bonds, conduct reclamation, and then have the division attempt to recoup any costs that are above and beyond the bond amount, recover that through what's called an administrative claim in the Chapter 7 bankruptcy proceeding. I can explain a little bit more about that as well, if the board is interested. But with that introduction, I'd ask that my witnesses be sworn at this time. I'm planning on calling Dustin Doucette and Joshua Payne for the division.
Proceed.
You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right, my first witness would be Dustin Doucette. Would you please state your name and position for the record?
Yeah, Dustin Doucette, petroleum engineer for the division.
And could you provide a brief background for these subject wells, specifically location, proximity to drainages and rivers, information of that sort?
Yeah, so both of these wells are located in close proximity to Cisco, Utah. The Nugget 14-4 in Section 14, noted there on Exhibit 1, is just northwest of Cisco, less than a mile roughly from the town of Cisco. The Gibraltar number 1 well in Section 24 represented there is basically in the town of Cisco. The Nugget is approximately a half mile from Cisco Wash. You can see the wash kind of winding its way through Section 23, which is a tributary to the Colorado River, which is approximately probably seven miles away. And the Gibraltar well is about 3/4 of a mile from the wash, and like I said, is located in the town of Cisco. The Nugget 14-4 well was spud on October of 1978, and the Gibraltar was spud in February of 1983. As far as production, the Nugget first started producing in 1994, and last produced in 2016. Has produced a cumulative amount of 4,158 barrels of oil. The Gibraltar well first produced in 1983 and last produced in 2016, with a cumulative amount of 1,233 barrels. As far as prior operators of the well, the Nugget 14-4 well was first drilled by CC&Co, and they went into bankruptcy and dissolved. We had put it with some other wells at that point in time on the orphan well program in 2002. Subsequently, we plugged other wells on that package, but another company came in and took over this well, Colorado, Utah Natural Gas. And then it eventually went to Pacific Energy and Mining, and then in 2007, and then Hinto in 2014. Gibraltar well was originally drilled by Walter Broadhead. It went to West Pettingill in 1991 through a tax sale, and then Marreg Oil took over in 2004, and Hinto eventually took over the well in 2014.
And in terms of active field presence, is there one for either of these wells?
No, there is not an active field presence. There hasn't been for probably a couple of years at this point.
Okay, thank you. All right, so I'm going to just show the board some pictures of the spill at the Nugget 14-4 well. I think I've got about 4 slides here, and if we'll just walk through each of these and just describe essentially the situation.
Okay, so this is the tank that was leaking. This is the oil that leaked out immediately surrounding the tank. And this happened on around February 11th, 2020. We were notified of this leak by the BLM. Initially, they had a realty specialist out in the area checking their leases, who contacted their office, and they subsequently contacted me.
Does the division know the cause of the spill?
The indications are that the valve on the tank had failed and allowed the oil to seep out of the that leaking valve and run down the drainage.
Okay. And could you just briefly describe these pictures?
So this is just showing the oil that has basically got into one of the little draws there and has run away from the location, heading roughly west towards Cisco Wash and a county road. This is just kind of more pictures showing, if you can see up on the first picture on the very top there, that's the actual tank that was leaking. So it's run across a location down to that lower tank, and then kind of found the little draw there and ran down the draw. And this is just a picture a little bit further down. You can still see the tanks in the picture in the far right. This is kind of the terminus of where the oil was at this time, which was on February 11th, I believe these pictures were taken. This is actually in very close proximity to the county road, and I think are we going to go to a map that maybe shows, well, we'll go to a map and kind of show how close proximity it is to the road. Okay, here it is, where that, so Cisco Wash, basically where that yellow arrow is, the county road, where that terminus of that leak was when we found it, was just, if you went due southwest of that Nugget 14-4 pin there, it was right kind of next to the road. I don't know if you can kind of highlight.
So if I show you here with my cursor, this is approximately where the oil spill was.
Correct.
Either, I believe it was February 12th the pictures were taken.
Yes, I guess it was February 12th. We were notified on February 11th. Our inspector went out there first thing on February 12th, got those pictures, and we commenced the work. After we got everybody, or got a contractor out there, that oil was right at the road, so getting ready. And if you can see on this picture, there's a little bit of a slope going in beyond the road, but it quickly gets into the wash after that. So we had to take action pretty quick to keep that from happening.
And once the oil reaches the wash, what is the likelihood of it eventually reaching the Colorado River in this case?
A lot of this, is on the Mancos Shale and doesn't soak in. It could soak in down in that wash a little bit, but anytime you get a rain event, it could push that easily into the Colorado River. Yeah.
Okay. And moving back just a slide, this is a picture of the valve that is leaking.
That was a valiant attempt by our inspector to do any. I think he just wanted some new coveralls, but I think his motives were pure here. He was actually trying to keep any additional from leaking out. I hope he did. I didn't want to ask, but.
So, besides this valiant effort to contain the spill, what other actions has the division taken to contain the spill up to this date?
So like I said, we worked with them, with contractors on Thursday, and awarded the bid to the lowest responsible bidder that we did. We had three personnel that were, or companies that were in the area that were able to do this work. We awarded the bid to the lowest bidder, and they were able to get out there first thing on Friday or midday Friday, get this all bermed up, and berm around the tank as well, disconnect the tank from the wellhead to make sure we didn't have anything else flowing into the tank. And because it was still pretty wet in a bunch of areas, we were able to let it dry out over the weekend, and we came back on Monday, Tuesday, and scooped up the oil and mixed it with some of the Manco shale out here, and took it to the landfill and disposed of it.
And approximately, how much has the cost been to date to perform that remediation?
So the work's all done. I'm still waiting for the final invoice, but it's roughly $11,000.
And these pictures have all been depicting the spill at the Nugget 14-4 well. Can you address why another spill is imminent at the Gibraltar 1 well?
Yeah, the Gibraltar 1 well is in, well, one issue is it's right there in Cisco, in close proximity to Highway 128 and the town.
I'm going to interrupt you, but specifically, why would another oil spill occur at the Gibraltar 1 well? I'm not sure if I asked you that correctly.
Well, I was getting to that, but I'll continue on that way. So, like I said, it's in the town, but it has similar equipment, same kind of age of equipment. It does have a tank that is fairly full of fluid of some sort. We don't know exactly what it is. These typically don't make a lot of water, so we'll probably assume it's majority oil. And so that tank could very easily leak. We've had some spills on the Gibraltar well in the past. Some minor ones, like 2017, I think was the last, May of 2017. I think it was like a 5-barrel spill, something like that. But there's definitely potential for that to leak.
And specific to the tank that was on site at the Nugget 14-4 well, is the storage tank that's on site at this the Gibraltar 1 well, is it the same make and model or similar?
I would say I couldn't testify whether it's the same make and model. I'd say it's similar though, yeah.
It's of similar age?
Yeah, that would be my guess as well.
And
I mean, one other thing I would mention are, with no oversight from an operator, we also have the chance that these can be, valves could be turned, stuff like that. And it's kind of out in the middle of nowhere to some degree, but they do get a lot of traffic out here. So that's one safety measure of having, a field presence out there, is that you can kind of look after those kind of things. Right now, we don't have that without the operator, constantly being out there and pumping these wells or looking after these wells. So even if the tank is in good shape, even if the tank doesn't fail, you could have some other, valves opened, et cetera. The wellhead could leak, stuff like that. So.
All right, and I'm going to ask you just a couple of questions about how the area of land that surrounds the Gibraltar 1 well, how it's used. First, is there any sort of grazing sheep or cattle?
Yeah, there's been sheep and cattle out in this area. I know they do run some cattle, I think typically to the west, directly to the west of here. And a lot of this area does have some sheep grazing as well.
And then I'm going to point out this road to you on the map, the Cisco Pump House Road. Do you know where this road leads, and is it used by people trying to access the Colorado River?
Yeah, I think it's roughly 7 miles to the input for rafts and stuff like that.
And I believe it's a popular access point for Westwater Canyon.
Correct, yeah.
Okay, thank you. And have you estimated the cost to plug and abandon these wells?
I've got one for the Nugget 14.4 that I prepared back when we were going to put it on the orphan list, or when it was on the orphan list. So I do have that, and the Gibraltar would be somewhat similar to that well.
And what are you estimating in terms of costs to do the P&A and surface work, not including the remediation to date, but also including mobilization and demobilization?
So the cost estimate just to plug the well is roughly $27,000. I had testified earlier today as well, as far as mob costs, could be, you know, $20,000 to $30,000 on top of that, and then some reclamation. The Nugget has a few things to dispose of, maybe a little more reclamation than we typically do out in this area, as these pads are typically pretty flat. But just an estimate of maybe $10,000 or maybe a little bit more for that. So I guess if we add all that up, we're looking at roughly 65,000 or 60,000 possibly, if you spread it out across the two for each well.
Okay, thank you. I have no further questions for this witness. If the board would like to ask them now, or
Board members, any questions at this time? Okay, Mr. Brown.
Listen, that looks like a ball valve on that tank. Is that typically what they are?
Yeah, not always this
Could
type
be
of
a gate.
valve.
The reason I'm asking is, how do we know that tank wasn't vandalized and the lever opened and then failed in the closed, or open and failed in the open position, and the vandal left? Are we absolutely sure this wasn't an act of vandalism?
I mean, I don't think we're 100% sure. I mean, I haven't viewed this myself. I mean, our inspector looked at it. We had 3 contractors look at it. All of their expertise said that the ball valve failed and leaked.
I don't doubt that it failed, but it could have been an act of vandalism. When they opened the valve, it failed open when they tried to close it because of the age of the valve.
Yeah, could have been. Another factor that, if you, I mean, it's pretty well corroded, that valve, and our inspector said the threads on there were just, you know, really corroded. So it was the valve that failed, but it's close to other failures probably in the tank itself.
Okay, maybe I'm beating a dead horse. Was the valve open?
No, the valve was not open.
Handle said it's closed. I can see that. Was the ball valve open?
I don't know for sure. They said it looked like it had cracked that ball valve in there. That's the report I got. I don't
Understand?
Yeah, I understand what you're saying.
If that ball valve is open, it almost suggests somebody opened it and it failed when they tried to close it, and it was an act of vandalism. I would at least double check that valve didn't fail open.
That's not the indication I got from the field people. They indicated it was closed, and it was a failure of the ball valve itself, not that it was in the open position where you could see that it was open. But I can definitely check into that as well.
And then one other thought, this other tank where there's an imminent threat, can we slam a game cam or something on that just to make sure we don't have some vandals come around and...
I'm not sure if the division would have the authority to post a trail camera because the surface is owned by a fee owner, a private landowner. There may be the ability for the division to do something like that. I will say that if it was just typical open fields, like for instance, BLM land or SITLA land, then it would be permissible for the division to do such activities.
Couple of suggestions from an old redneck. Thank you.
Thank you.
Other questions from the board? Go ahead, Mr. Church.
You mentioned that one of the tanks appears to be full of some kind of liquid. Are there salvage costs that anyone can recoup, or how would you dispose of those fluids when you reclaim the well?
For us, yeah, we can't capitalize on that because it's not our oil to sell necessarily. Typically what we've done is have to haul that off, and the recycled, wherever the recycled place we take it to probably ends up getting the benefit of that. We've reached out typically to, in cases where we had them on SITLA ground or SITLA leases, seeing what they could do, and they were kind of a similar opinion that it was hard for them to do stuff. But I mean, I don't think we can't sell the oil, and we don't know who to pay on that. And
Why not?
Why
Tell me why not? You have an existing threat to health, safety, and welfare. You have clear indications from an owner, the trustee, that they're not going to do squat, and that there is an immediate threat necessary for an emergency hearing.
I don't have a perfect answer for that question, but I would say that oil still is owned by the trustee. So even though they've abandoned this well, essentially, that oil belongs to the trustee, and there would be a way to sell the oil and offset the costs of reclamation, but I think the first person who would have a claim to that would be the trustee.
Of course they would, but would be the same thing if you had a fire on a building and you were able to get some way to get it, conserve it or retain the value of the asset. You'd still get to be able to charge to get your administrative costs. I don't want to jump ahead of what your witnesses are going to say, but it seems like to me there's two different parts of it, the money and the problem. In terms of the problem, you've got clear evidence that the person entitled to the oil or whatever liquids are in there isn't going to come get it or isn't going to do anything about it. And I believe that the board and the division need to look at this seriously and say, can we drain those tanks, sell it, or take it to something where it can be handled, and then the cost of the transportation and the cost of actually doing that can be deducted, and then whatever over the top of it has to go to the trustee, not used in reclamation, or not used in plugging the wells. I don't know that that's appropriate, but to solve the problem, I mean, if you had a truck fall over on an overpass on the freeway, the fire department can drain it. And so there has to be some way we can solve this. I may be way out of line on this, but
I don't know exactly what authority the division has, but I'd be happy to take a look into that as part of the board's general authorization of
and in terms of
future actions for the division to take to address this.
So what I'm saying is, let's say that you got $20,000 in terms of revenue from that, and it cost you $3,000 to pick it up and truck it. You should be able to get your $3,000 back, turn the $17,000 over to the court, and ask that that be used to offset it. Whether you get it or not is up to the Colorado bankruptcy judge. but don't leave it festering.
I don't think we're going to leave it. We're not going to leave it there. We will dispose of it properly. It's just a matter, can we sell it or can we not? In the past, the issue's been, I mean, we're not set up with contracts to sell oil. So, I mean, I don't know how we, affect that. The other issue is.
Don't sell it. Get rid of it.
No, we will get rid of
it's,
it.
if you're going to wait and then you're
I just
going
said
to
we
clean it
wouldn't
up.
be able to sell it. That was my testimony, that we wouldn't be able to sell it. I had testified that we would get rid of it. We'd take it to a disposal site. They're able to market that. So the question comes down, can we actually sell that? I've looked into it in the past, and our attorneys are going to have to weigh in on what we can and can't do. I mean, my issues I've run into is who has the right to that, because if we sell that, there are interest owners that, maybe royalty owners or whatever, that may have some rights to that oil. We don't know. We don't have contracts set up.
Let the judge decide that.
We don't have contracts set up to sell that oil. So I don't know how we get
It's
those
almost like
contracts set up.
And there ought to be a solution in this, and there's an emergency provision in the statute that allows us to have an emergency hearing for health, safety, and welfare. Is there a linkage to that, to some action we can take to solve it? Surely we have some authority to solve an emergency problem.
I think the board's authority is limited to the confines of the Oil and Gas Act, which would essentially leave them in a position to forfeit the reclamation bonds. However, my co-counsel would be happy to look into future actions the division could take to mitigate the costs in this action. I think it's something that I have not looked at in preparation for this hearing, but there may be authority that exists.
To the extent, I mean, I think you've made your primary case and you've met your duty of meeting the evidentiary standard. Other board members, do you feel that they've made their case on this? I mean, it's clearly that the bond need to be forfeited. The question of, is there any advice for putting penalties on these guys? Because clearly, at $5,000 a day, there ought to be something out there that is a penalty.
The clearest path to a penalty is violation of R649 3-15, which is essentially asking operators to not spill oil on the ground, specifically to take actions to prevent that spillage of oil from entering natural drainages or washes. And a $5,000 per day of violation seems appropriate in this case.
Would the division feel like they are at a disadvantage in any way if the board requested that we go to a decision in the interest of time, or you feel strongly that the record needs to show your next witness? Could you proffer what your next witness would say?
I will proffer that the next witness will say that these wells are in violation of R649 3-36, which is failure to report evidence of downhole integrity, which again only adds to the threat to the health, safety, and environment, because if you don't know what's going on in the well bore, you're not sure what's happening you're not sure if it could have a negative effect on the surface, but also in the subsurface in terms of if the water table or anything is being affected there. And that the way to mitigate this risk at this point in time is to plug and abandon these wells and to do the surface work that is necessary. So with that, I would request that the board order the forfeiture of the bonds to the division, authorize the division to conduct reclamation, authorize the division to file a civil action in an appropriate court if the bonds do not cover the cost of reclamation, and specifically that would be filing of an administrative expense claim in the bankruptcy court, and authorize the division to pursue civil penalties against Hinto Energy, Inc. for violations of the rules.
And in what amount would you recommend for penalties on this, at $5,000 a day, or actually maybe more than that, but
I think at a minimum, it would be 7 days of the spill. So from February 11th to remediation was February 18th, and the maximum per day, $5,000 per day. So a total of $35,000 of penalties.
Board members, do you understand what they're recommending?
Just one final question. Dustin, what do we need to make the,
Roughly 60 grand probably each. That's if we mow out just for these 2 wells.
Thomas, is the penalty calculation enough to go with the bond and cover the deficit?
I don't think it's quite there.
Board
But
can order
yeah,
$10,000 a day if they find and believe it's willful.
Well,
It'd be
I
$70,000.
don't think we have put forth testimony that demonstrate this violation is willful necessarily. However, there is the ability to approach the bankruptcy court to recover the costs of the reclamation. So the penalty in this case would be a true penalty amount. It wouldn't not just be to cover the costs of reclamation. Any dollar that the division spends to address this spill can then be requested in front of the bankruptcy court. So I think there's a clean line between the costs of reclaiming the site and a penalty that's ordered.
Board members, any closing arguments?
No, I think immediate closure and plugging abandonment of these wells will serve the public well, and the BLM would appreciate it, and I'm sure the town of Cisco would appreciate it. So the quickest action we can take on this would be beneficial.
Restate what your request was. And I'd like to make sure everyone understands, at the end of what they're requesting, I'm going to ask that we examine our law, and to the extent we can mitigate the perceived problem based on the assumption or the direct information that the trustee is not going to do anything, that we can take custody of that oil so that it can't be spilled, and that we dispose of it as best we can within the law that allows us to do that, and that anything above our actual cost of doing that be returned to the trustee and to the court. Okay, that's your conclusion?
Yes, sir.
Okay, everybody have this in front of them. We have the conclusion. Is anyone willing to make a motion as to those 4 and possibly a 5th one, which is to the extent the law allows us to take custody of this and to do something with it so that the spill is mitigated or avoided, based on the representation that the trustee was not going to do anything. Again, to the extent our laws, rules, regulations allow it, which would be number 5. Anybody willing to make that motion?
I'll make a motion.
Okay, there's motion before you. Is there a second? Okay, any discussion? Any additional input?
No, nothing from the division.
Hey, Mr. Rowe, let me tell you, the motion before the board, and I'm going to ask you to vote, is the 4 items on the screen right now, plus an additional one, to the extent our laws, rules, regulations allow for actions that are in the benefit of the health, safety, and welfare, that you take that to the fullest permittable levels, that it's able to be sold, fine. If not, fine. To the extent you can break even on the cost of just mitigating that, just getting it to somewhere other than a spill, and that a penalty is $35,000 would be in line. Does everybody understand that? So it's actually 6 elements to the order.
I believe the 4th element on the slide is the authorization of the penalties. So
Yeah, okay, and the penalty amount, I beg your pardon, is the $35,000. We have 5 of them. Okay, all in favor, say aye.
Aye.
Any opposed? Let the record show 2 things. Number 1, the vote was unanimous, and number 2, that Mr. Gordon Moon had to leave in the hearing and didn't participate in the final decision. Is there anything else to come before the board today? Yes, Mr. Baza.
Mr. Chairman, this does not have to be on the record, but
Okay, we're off the record. A motion. Okay, we are off the record, and I'm going to delay the, what's that? I'm going to delay the motion to adjourn, but we're off the record for just a minute.
I hope you'll allow me a moment of personal privilege, as they do in the legislature. But we mentioned this morning that this was Thomas's last day with us. He's actually extended his time with the AG's office on our behalf. We will have a new attorney starting at the AG's office. I think you may have already heard on Monday of next week. So this was appropriate timing for Thomas to stay through this hearing. But I wanted to say thank you personally and acknowledge Thomas's value to us. I think if you look at the last 3 months, the division has gotten a lot of work out of these attorneys who have come through the O'Hara Fellowship Program. And I want to give my highest praise to Thomas and to Gordon for carrying a lot of load for the division over these past 3 months. So I want to wish him well, and I want to say thank you to both of these attorneys for the hard work that they've done for us.
Thank you for saying that. That's very appropriate. I think I speak for the whole board in welcoming Gordon to a higher level of involvement. And Thomas, Godspeed, bon voyage. Anyone else want to say anything?
Thank you very much. It's been a pleasure to represent the division in front of the board. Thank you.
Thank you. Thank you. You've done some great work. Motion to adjourn is in order. It's non-debatable. Okay, all in favor say aye. Aye. We're off the record. Oh, yes, we're back on the record. All right.